Good afternoon, good morning, good evening. My name is Martins Paperinskis. I'm reader in Public International Law at University College London, and it's my great pleasure to welcome you to the online conference on the Implementation Committee of the Convention on the Protection and Use of Transboundary Watercourses and International Lakes. This wonderful instrument, in short, the Implementation Committee of the Water Convention, on which I have a privilege of being a member. This conference is co-organized by 4 institutions. First, University College London, within the virtual space of which we reside now. Secondly, University of Bologna, from where we have Professor Attila Tanzi, chair of the Implementation Committee, to whom I will give the floor in a minute. United Nations Economic Conference for Europe, UNEC, from where we have Sonia Koppel, the secretary of the Water Convention, who will speak after Professor Tanzi, and the University of Pacific, McGeorge School of Law, from where we were hoping to have Professor Stephen McCaffrey, who unfortunately will not be able to join us, but I'm sure that, again, his momentous textbook on the topic will be on the library shelves of many of the audience and will be, in that sense, with us. Before I give the floor to Professor Tanzi, let me make 2, as it were, housekeeping remarks. First, our intention is for this conference to be not merely a fleeting, albeit hugely exciting intellectual endeavor, but a permanent virtual space for information about the Implementation Committee of the Water Convention, an asset for all of those who practice or teach anything relating to international water matters. So on the webpage, you will find an extensive bibliography on the Water Convention, and also after the conference, recordings will be stored there, as it were, permanently. So for anybody interested in water law matters, that should be a resource of first try. Secondly, let me say a few things about the structure. As you would have seen from the program, we will have 2 panels. The first, I will have to step in and to chair it instead of Professor McCaffrey. That will start immediately after these remarks on the place of the Implementation Committee in the broader body and institutions of the Water Convention. Then from 3:30 to 4, we will have a break, and you'll have an opportunity to join the speakers and other attendees in the Wonder Room. Don't be skeptical. I was skeptical myself, but actually I have found it a hugely enjoyable way of meeting people, particularly for those who are slightly introverted and might find it otherwise awkward to talk to unknown people. And at 4 o'clock, we will reconvene again with Professor Attila Tanzi chairing the second panel and a roundtable discussion on this topic. And at 5:30, we will conclude with my colleague, Professor Philippe Sands, joining us from the virtual space in The Hague, where he's arguing a case in the International Court to give closing remarks. So I think a fantastic day ahead of us. Dear Professor Tanzi, dear Attila, the floor is yours.
Can you hear me now? Right. Well, thank you very much, Martins, not just for giving me the floor, but for having taken the lead in the organization so effectively, having had the idea of holding this event together, and tremendous efforts. I'm also grateful to Steve. I'm sorry that he can't be with us today. I'm grateful very much to the UNECE Secretariat in its contingent, in its plenary configuration. They are the backbone of the convention and of every individual subsidiary organ, our committee included. Around that backbone, we can articulate our water diplomatic gestures, further assisted by them. So without further ado, I'm very pleased to be giving the floor to Sonia, who represents that contingent. And You have the floor, Sonia.
Thank you very much, Attila. Good morning, good afternoon, good evening to some. Ladies and gentlemen, as most of you probably know, 60% of the world's freshwater flows in transboundary basins. And almost half of the world population is living in such basins. For this reason, achieving SDG 6 requires effective transboundary water cooperation. Transboundary cooperation is also crucial for other SDGs, including peace, health, food and energy, and others. The SDG target 6.5 was therefore a great step forward. It requires countries to implement integrated water resources management at all levels, including through transboundary cooperation as appropriate. The SDG indicator 6.5.2 measures the proportion of transboundary basin area with an operational arrangement for water cooperation. The two monitoring exercises of this indicator carried out so far by UNEC and UNESCO as custodian agencies in 2017 and 2020 show that we need to accelerate progress on transboundary cooperation. In fact, only 24 of the 128 reporting countries achieved the target in 2020, meaning that they have all their transboundary waters covered by operational arrangements for water cooperation. On the other hand, the positive news is that the second reporting exercise just completed has shown greater engagement than the first one, with over 80% of countries sharing waters sending their reports. If we look at the results, regionally speaking, transboundary cooperation is more advanced in Europe, North America, and Sub-Saharan Africa. Whereas many rivers, lakes, and aquifers in Latin America, North Africa and Western Asia, Central and Southern Asia, and Eastern and Southeastern Asia lack operational arrangements. Especially there is insufficient cooperation and knowledge on groundwater systems. In this regard, we need capacity development, financing, data information, and much more such as decisive political action to achieve the target. UNECE is supporting development and implementation of transboundary agreements and transboundary cooperation in general through guidance, projects on the ground, and capacity building in the framework of the Convention on the Protection and Use of Transboundary Watercourses and International Lakes, known as the Water Convention. As many of you know, the Water Convention provides a unique, now global legal and intergovernmental framework and UN platform for the peaceful management of shared waters, contributing, together with the Watercourses Convention and many other agreements at all levels, to sustainable development, international peace, and security. Since 1992, the Water Convention has greatly accelerated progress towards transboundary cooperation. Out of the 24 countries which I mentioned earlier, which have all their transboundary waters covered by operational arrangements for water cooperation, 19 are parties to the Water Convention. Following the Convention's opening to all United Nations member states in 2016, the Convention currently counts 44 parties. 20 countries are in the process of accession, and more than 130 participate in the Convention's activities. The Convention's meetings are open to all countries, intergovernmental organizations, academia, and NGOs. I invite you all to join, on the one hand, for example, the working groups meetings next week under the Convention, and most importantly, the Convention's 9th meeting of the parties, to be held on 29 September to 1st of October 2021 in a hybrid manner. One of the main added values, I would say, of the Water Convention is its institutional structure, including the meeting of the parties, the working groups, task forces, expert groups, etc., in which many parties and non-parties are very active. And I'm very happy that several of the big promoters of the Convention will be also speaking today. Another added value of the Water Convention is its flexibility and adaptability according to the needs of the countries. For example, when working on the implementation guide around 2009 to 2012, parties realized that a mechanism was missing under the convention to support implementation. After several rounds of negotiations by the legal board, where some persons present here were very active, such as Attila Tansi, they developed a proposal for a non-adversarial cooperative mechanism, namely the implementation committee. It should be an independent convention body with 9 members serving in their personal capacity. Experience of other compliance and implementation bodies were taken into account. For example, of the ESPO Convention and of the Convention's Protocol on Water and Health, which has a compliance committee, which accepts, for example, also communications from the public, a very interesting mechanism. In 2012, then, the 6th meeting of the parties of the Water Convention decided to establish the implementation committee. Thus, the committee so far existed for more than 8 years and has supported many activities under the convention, such as the first reporting under the convention. It has also supported the Secretariat in answering questions by countries in the accession process, and just recently concluded its first advisory procedure. We will hear more about all this in the course of the discussions today. However, the committee is still not known enough. That's why I'm very grateful to Martins Paparinskis and his team at the UCL for organizing this event today with such distinguished speakers from all over the world, including from the committee and beyond. I would also like to recall that some 6 years ago, Professor Tansi and some colleagues led the preparation by a group of some 30 authors of a book about the Water Convention, published by Brill, which probably many of you have seen. This exercise has led to increased interest in and knowledge about the convention in academic circles. Since that time, the convention has considerably grown in terms of the scope and scale of its activities, and also in terms of the parties. I hope today's event will draw further attention to the convention, its implementation committee, and progress made, as well as what is still needed in the coming years. I would therefore like to thank once again in advance, on behalf of the Secretariat, Mr. Martins Paparinskis, Professor Tansi, and their colleagues, but also all speakers today and all participants and everybody else who contributed technically and in other ways and manners. I wish you and all of us today an interesting discussion, and I look forward to seeing you also at some of our upcoming events, such as the meeting of the parties at the end of September. Thank you very much, and I wish you all the best.
Well, many thanks, Sonia, for the extraordinarily kind words and for all the extraordinary support that the Secretariat has always provided us. I think that we can now move, as it were, in the virtual space for the first panel, where I will be the fallback chair for this session. So just to remind us of the purpose of this panel. As we heard, Implementation Committee is an important body of the Water Convention, but it is part of the broader universe of institutions, mechanisms, and actors within the Water Convention universe. So it is very important to appreciate where it fits, what its main characteristics are, and how it operates. And therefore, members of the first panel will consider the fit, disciplinary, normative, substantive, legal, and diplomatic of the committee within the convention. Let me just remind briefly you of the, as it were, the roadmap. In a minute, I will introduce the speakers and their topics, and we'll give them the floor. And while they are speaking, audience can use the Q&A button to ask questions. After the speakers have finished their presentations, I will collate the questions and present them. So don't be shy at all. Please ask as many questions as you feel would be interesting. And I'm sure that if we don't get to them today, these will be valuable reflections about what is important to the international water community. We have 5 fantastic speakers, and they are full, even if very short bios are on the website. So I hope that you'll permit me to be rather selective. But they certainly, individual and as a whole, have an extraordinary wealth of experience in these matters. And I will introduce all of them together. The first speaker will be Yulia Trombitskaya, who is an environmental affairs officer at the Secretariat, has an extraordinary wealth of knowledge in UNEC and water-related matters since 2009. And if may I add, her encyclopedic knowledge of Water Convention has been an extraordinary asset to the Implementation Committee in its everyday work. Yulia will be speaking on the Water Convention and new directions of work. Her presentation will be followed by Peter Kovács, who is Hungary's representative as the EU Water Director and has, again, an extraordinary wealth of experience in everything related to water law and diplomacy, bilaterally, multilaterally, in all possible settings for the last 25 years, and comes with a really unparalleled experience on Water Convention as its former chair and current vice chair. And Peter will be speaking on the development of soft law tools under the convention. Peter will be followed by Sibylle Vermont, who comes to us from the Federal Office for the Environment of Switzerland, where she's lead on environmental and transboundary water matters. And I know that her interest in water extends beyond freshwater, and she's currently engaged in negotiations on BBNJ matters, which I think are also of interest to some of the audience. It gives me my particular pleasure to introduce the last 2 speakers, my colleagues from the Implementation Committee. First, Dr. Dinara Zaganshina, who is the Vice Chair of the Implementation Committee and the Deputy Director at the Scientific Information Center of Interstate Commission for Water Coordination in Central Asia, and has also a wealth of experience in legal and water diplomacy matters, particularly, although not exclusively, in that region. And Dinara will be speaking in committee's mandate and the intersection it occupies between law and diplomacy. And the final, but by no means the least of our speakers, is Pedro Cunha Serra, a member of the Implementation Committee and one of the, if not the leading Portuguese expert on water resources matter, with an extraordinary wealth of experience in representing Portugal in various capacities on these matters and involved in settlement of water-related matters in Europe and beyond. And Pedro will speak on the role of science in the Water Convention. I think that is a theme that will also be running through the mixed legal and scientific character of the Implementation Committee. So I think really a fantastic array of speakers and themes. I think that concludes my role here, and it is my pleasure to pass the floor to Yulia. Please.
Thank you very much, Martins. So it's my pleasure to present to you today the Water Convention, also known as the Helsinki Convention or UNEC Water Convention or the 1992 Convention. I will start from a little bit of history because we are often asked how did a convention emerge and why it is hosted by UNEC. UNEC is one of the 5 regional commissions of the United Nations. In the 60s, it had a very active committee on water problems who developed many soft law instruments that introduced some new concepts in water management and environmental protection, such as the ecosystems approach. And in late 80s, when Europe had seen major political transformations, countries of the region decided to negotiate several conventions on transboundary issues, including on transboundary waters. And UNEC was simply the most appropriate forum for such negotiations. The International Law Commission was at that time working on the draft articles on the law of non-navigational uses of international watercourses, which later became the 1997 Watercourses Convention or the New York Convention. And countries of the UNEC region were, of course, fully aware of that work that lasted several decades, but they were also much faster to negotiate a regional convention. So the convention was signed in 1992 and entered into force already in 96. Next slide, please. So after that, the convention came right on time. Many new borders emerged in Europe, Caucasus, and Central Asia, and dozens of new agreements were concluded on the basis of the convention. Actually, the EU Water Framework Directive was largely inspired by the convention. Countries from outside the region started to express interest in the convention. So in 2003, parties to the convention amended it to enable countries from outside the UNEC region to join this instrument, and in this way to broaden political support for transboundary water cooperation. The amendments entered into force in 2013 and became operational in 2016. Next slide, please. So the Water Convention has three pillars. It's fully in line with international customary law and based on it. And its three key pillars are the due diligence obligation to prevent transboundary impact, the equitable and reasonable utilization principle, and the obligation of cooperation. Next slide, please. The convention has two sets of obligations. So its part one provides obligations for all parties, and part two includes obligations for riparian parties. The obligations for all parties help countries take measures to prevent and control transboundary impact. And these obligations include use of permitting, environmental impact assessment, setting of emission limits based on BAT, prevention of accidental pollution. They also improve national water management, in addition to helping countries prevent transboundary impact. Next slide, please. The second set of obligations for riparian parties, apply to parties sharing the same transboundary waters. And here, the key obligation is the requirement for riparian parties to enter into specific agreements and establish joint bodies for their shared waters. This obligation, along with the obligations to hold consultations, exchange information, do joint monitoring and exchange, they help countries to actually implement their core obligation of cooperation and define what is equitable and reasonable in their particular case and how to apply the no harm rules in their circumstances. Next slide. So, but the convention is more than a set of obligations. It has a developed institutional platform with the meeting of the parties as the highest decision-making body. The meeting of the parties adopts every 3 years the program of work. The program of work is implemented by working groups, task forces, and other bodies created by the parties to implement activities in specific areas of work. And you can also see on this chart the implementation committee is part of this structure. This structure is quite flexible, so new bodies are created and old ones become non-operational depending on the activities in the program of work. This is a unique platform under the auspices of the United Nations to discuss progress in transboundary water cooperation, and it is open to all interested countries. Next slide, please. So, as already mentioned, the convention has considerably grown in the past years. It now has 44 parties, including 3 parties in Africa, Chad, Senegal, and Ghana. You can see them in green. There are 3 countries which are very, very close to accession. These are Iraq, Guinea-Bissau, and Togo. You can see them highlighted in blue. In Iraq and in Guinea-Bissau, accession is finalized, and only the instruments of accession remain to be deposited in New York. There are also a number of countries in the process of accession, but not so close to accession so far. You can see them highlighted in yellow. So they are mostly in Africa. These are Burkina Faso, Cameroon, Gambia, Democratic Republic of Congo, Cote d'Ivoire, Uganda, Nigeria, Tanzania, Tunisia, Lebanon, and in Asia, Vietnam. Next slide, please. One issue which often emerges, especially in the legal audiences, is the relationship of the Water Convention and the 1997 Watercourses Convention. There have been many studies which demonstrate that the 2 global water conventions are fully compatible and, in fact, complementary to each other. The United Nations Secretary General is calling upon countries to join the package of 2 global water conventions. And there is now a UN system-wide commitment to promoting the 2 global water conventions. Such commitment has crystallized with strong support of parties to the Water Convention, in particular those 17 countries that are parties to both instruments. And it has also been very much promoted by UNECE. Parties to the Water Convention in the program of work have entrusted the Secretariat to provide capacity building in support of both conventions, subject to the interest of the country. And in Ghana, the Water Convention Secretariat provided capacity building on the 2 conventions, and Ghana joined 2 conventions at the same time. Next slide, please. So the program of work of the Water Convention is adopted every 3 years, and it includes many topics. So this is support to development of agreements, support to accession, monitoring and assessment, water allocation, nexus approach, climate change adaptation, financing of transboundary water cooperation, a relatively new area, and also the reporting on the Water Convention and SDG indicator 6.5.2. These activities are implemented at several levels. There is exchange of experience at global level through global workshops and development of guidance documents. Also, some activities are implemented at regional level. Support to negotiation of agreements and other activities are provided in specific transboundary basins, and we also have some activities at national level. Next slide, please. So here you can see a map which basically maps or shows the activities, the various thematic activities of the convention and the basins engaged in the implementation worldwide. The convention is already, in fact, acting globally to support transboundary water cooperation. You can see many activities happening in Africa and some in Asia and Latin America. And here the convention works with many partners. It would not be possible simply to embark on these activities without many intergovernmental organizations, NGOs, and regional organizations who support these activities. Thank you. Next slide, please. Here I would like to shortly tell you about one program area, climate change activities. Here the convention assists transboundary basins to benefit from joint planning and implementation of activities on adaptation to climate change. Joint measures in this area help countries to reduce costs, enhance benefits and sustainability of measures implemented. A task force on water and climate under the convention has been leading the activities in this area, which made the convention pioneer the approaches to climate change adaptation in transboundary basins. There is also a global network of basins who regularly share experience on adaptation to climate change. And the relatively new direction of work in this area is assistance to countries in preparation of bankable projects to climate funds. Next slide, please. And my last slide is about the protocol on water and health. This is the only one protocol which is currently in force of the Water Convention. So the protocol on water and health is jointly serviced by UNECE and WHO Europe. Its key objectives are access to drinking water for everyone and provision of sanitation for everyone. It is a regional coordination platform to exchange experience, build partnerships, and share data on water, sanitation, and hygiene across sectors. The protocol improves governance and accountability on water and health through such mechanisms as target setting and reporting. Currently, it has 27 parties, but over 50 countries regularly participate in its activities. And it has a special focus on the human rights to safe drinking water and sanitation through its work on equitable access. Thank you. And my next concluding slide here, you can see the website of the convention where you can find a lot of information about our activities, our products, and you can also see the Twitter and Facebook accounts. Please do follow us on these accounts. Thank you.
Well, many thanks, Yulia, and probably the only two things to add is that one, I suppose, very human example of the mutual supportiveness and consistency between the Water Convention, Watercourses Convention is, of course, that Stephen McCaffrey, the member of the Implementation Committee, was one of the special rapporteurs of the International Law Commission's work on the matter. So there is perfect consistency. And the second is that I already see that there are quite a few questions coming in, which is fantastic. And you could just identify whether you are asking the questions to the panel more generally or to a particular speaker. All right. Well, I think that now I can give the floor to Peter. Please, the floor is yours.
Yes, thank you very much for the floor. I hope you can hear me well. It is a real pleasure for me and an honor to present a little bit about the soft tools and the other publications of which were developed under the framework of the UNEC Water Convention. I included the other publications also because there are numerous of brochures and other guidance documents and other papers which might be very useful when we are talking about transboundary water management. Next slide, please. First, the question, why we have to develop such a soft tool or soft law instruments? Because there is a need for that. As we feel, countries like to exchange experiences and also solutions related to the implementation of the Water Convention and also related with the implementation of the protocols, because there are many protocols also behind the Water Convention. For example, the protocol Water and Health, which might be very important if we just living in the COVID situation. And we have a lot of new challenges, like the climate change, which was just as an exemplar. The convention want to take up the pace with these new challenges as well. And we are trying to develop many tools to help to solve such a problems worldwide. And of course, we have to promote the good practices and tools and also lessons learned from international experience, because it's also very important to learn about the monitoring, assessment processes, how to develop agreements, and so on. And of course, all these activities are strengthening the cooperation between the countries. Next slide, please. So which are the instruments which were developed so far? I already mentioned guidelines, model provisions, policy briefs, recommendations, methodologies, and also I just want to call your attention, we are nowadays producing small postcards which are practically the front page of the publication, and on the back side you will have you can find a very short information and also information where to reach the whole document. It's very practical. Unfortunately, we do not have a face-to-face meeting nowadays, but it is our experience that people are willing to carry home such a small postcards instead of the big documents, because everything is available on the website of the convention. You see the website containing all the publications. You can scroll down all this kind of supporting material. And it's more than 300 entry if you are just making a search. So, and also it's very advisable to look for. You might find a very interesting topics over there. And just 2 exemplar, what we are in progress, which we are under development, the handbook on water allocation in transboundary context, and also the checklist on the development of agreements and other arrangements. So they are just living exemplars how these soft law instruments are produced. Next slide, please. So the process is just in a very, very simple form. So we have some idea requests from the parties, from the countries, from the convention bodies, and we are approving in the bureau or during the meeting of the parties that we have to develop such a guidance or document or other kind of document. And of course, we assessing the resources which are needed for such a development. And it's very important to mention that human and financial resources always in shortage, but we have a lot of very good experts who are volunteering and they are participating in the development processes free of charge. And it's also very important. And of course, we have to identify some responsible body for developing such a tools. It might be a lead country or the secretariat itself or the working group or the expert group or even an ad hoc group. And of course, it's necessary to find the appropriate people, the person, the experts who might contribute to the development of these tools. And we also in a position to be able to include external bodies like consultants or universities or other institutions if it's needed. And of course, if we have a financial resources for do that. And of course, the implementation committee also often invited or involved in the processes because many issues have a lot of implication related from the point of view of our legal ways. And of course, when we are elaborating the first proposal, we can start, or it's very good or useful to start an open consultative process. We would like to involve as many people and organizations as much as possible. And usually those documents also under discussion by the Bureau, and also during the next week, during the IWRM expert group meeting, we will put on the table the 2 documents which is under development, which was mentioned just a slide before. And of course, someone has to adopt those kind of guidance and other documents. And the meeting of the party is the body who is adopting those papers. Next slide, please. Just one exemplar. This is a recent exemplar how we are developing one of the new incoming tool, the handbook on water allocation in the transboundary context. I think it will be a very interesting document because we already collected many exemplars all over the world, how the countries are sharing their water resources. And it's very interesting to see what are the existing practices. And as you see, the process has started 2019, and when we had a decision made that we are developing such a handbook on water allocation. We knew it's a very sensitive topic and it has a lot of political and legal implications as well. So for example, the many legal experts were involved into the process, not only technical people. And as you see, the process went on. We established the expert group. They elaborated the first text, and after several discussion rounds, the expert group delivered the first draft, and it was discussed several times again. We took note of many of the comments during the process, And now we are almost in the final phase. Next week, we will discuss this during the Integrated Water Resource Management Expert meeting. And after, hopefully, by the end of the year, the meeting of the parties will adopt this document as well. Next slide, please. So the practical implementation of these soft law instruments. As I already mentioned, you can find all of them on the UNEC website. You can download free, and also by request, you can obtain a printed form. Just recently, the focal points or nominated points were asked if they need any kind of copies, and they had to indicate how many of copies and which languages. Because we have a good selection of languages as well available. Mostly the documents are available on English, French, and Russians, but due to the new interest from other parts of the world, we already produced some paper on Arabic and also on Spanish language. And of course, every country is free to translate into national languages those documents. And sometimes it's very useful. In the case of Hungary, my country, we also translated many of those UNEC papers because we have, let's say, limitations if we are providing these papers only on English or other languages for the experts. So it has an advantage if you have some resources and you can take, let's say, selection which are the most appropriate and most useful for you in the future. And of course, it's very important to implement those provisions or those guidelines. And there are many possibilities to start the implementation, to test the implementation. Many of the guidance documents already tested in different parts of the world. And it's also very good for us because it gives us a feedback how they are used in the field. We might have some improvement later on if we have a practical experience. And of course, I believe that these UNEC publications and other soft law tools are also influencing the global agenda and the global water governance, and also gives a good exemplars of the development of such a tools. And I think now, after the opening of the convention, as we have usually more than 100 countries participating during the different events of the UNEC, I think it's really important to use these tools. They are already developed, they are available, so let's use them as much as possible. Next slide, please. And I think this is my final slide. Thank you very much for your kind attention, and please use these instruments as much as possible. Thank you very much.
Thank you, Peter. That was, as expected, an extraordinarily rich and helpful presentation. I think it's, on one of the penultimate slides, really with sort of reminding the multilingual character of the convention, as the title page suggests. We may be speaking in English, but French and Russian are the other two authentic languages. It is now my pleasure to pass the floor to Sibyl on the strengthening of the institutional platform of the convention through the committee. Please, the floor is yours.
Thank you very much, Martins. And first, I would like to thank the organizers for inviting me on this topic. And I have to say, Peter actually set the scene very well for me. I mean, he spoke very much about the cooperation, the partnership, putting expertise together, taking challenges in their hands, and finding solutions. And I think this is very much the spirit about the convention. if we look at the strengthening of that institutional setup of the convention, there were different milestones. And the first one was in 2009, when at the fifth meeting of the Conference of the Parties in Geneva, we actually adopted a guide to implementing the convention. So that was a very important thing. It was actually needs driven. It is a comprehensive commentary of on the convention's provisions. So it will show explanations on procedural, legal, administrative, technical, and practical aspects of the convention's requirement. And it also has examples of good practice in the region. So this guide is very important, not only for parties that actually can enhance the implementation of the convention, but it is also a very important guide for non-parties to inspire them towards a possible accession. So that was really important. Now, the second milestone was, there is a second milestone, and if you read the convention, you will see there's nothing about an implementation committee. And as actually I'm negotiating BBNG, I wish we could actually borrow from the Water Convention one provision which is really important. It is in Article 17 under the meeting of the parties. It says under Part 2, at their meetings, the parties shall keep under continuous review the implementation of this convention, and with this purpose in mind, shall, under little f, letter F, consider and undertake any additional action that may be required for the achievement of the purposes of this convention. That was really that is a very important provision, because it allowed the meeting of the parties to agree on the need of a specific mechanism under the convention through which problems related to implementation and possible differences on the convention's interpretation could be actually addressed. During the meeting of the parties, we also recognized that there was something very special about the convention. It is its distinct cooperative spirit, which means that parties have to cooperate together, they have to come together. And also we looking at such a mechanism, we also thought it would serve as a platform for dialogue of non-confrontational nature, where countries might seek advice on their own, or might actually bring possible disputes, thus facilitating the implementation of the convention. So, of course, for such a mechanism, the guide is actually a key document, a key tool for that. A mandate at the time at the Conference of the Parties was given to the legal board to explore options for such a mechanism and to come back at the sixth meeting of the Conference of the Parties in 2012. There were 4 actually meetings of the legal board, and I did assist to the 4 meetings. And I have to say, it was very, very clear from the start that it was going to assist the implementation and compliance with the convention, but it was not going to penalize countries who would have problems with the implementation. The idea was really to assist the parties. And the title Implementation Committee came already on the first meeting. There was no discussion. Nobody wanted to see the name compliance. They wanted to see its implementation. Then when we looked at the members, and some of them are here with us, it was very quick to say they would have to serve in their personal capacity with diverse and great expertise. And even to the point that Switzerland actually proposed Mr. McCarthy, even though the United States are not actually a party to the convention, but due to his big expertise, we wanted him to be on the implementation committee. There was a third milestone in 2012 at the 6th meeting of the Conference of the Parties. We took a decision to establish that implementation committee as a subsidiary body to the convention. And among its tasks, I think it's very important to mention that we said it should facilitate, promote, and safeguard the implementation and application of and compliance with the convention. We also encouraged parties, and surprisingly, we also addressed non-parties to make use of the mechanism. And for us, this mechanism had to be simple, non-confrontational, non-adversarial, transparent, supportive, and cooperative in nature. And if you look in the appendix to the decision that was adopted at the time, I looked through it last night, and in fact, I realized that assistance, the term assistance, is referred 11 times in it. So it's very much a service mechanism towards the parties. Either a party has a problem, doesn't know how to deal with some issues with its own implementation, or some parties are coming together and saying, well, we do have a problem and we don't know how to deal with it. Then the implementation committee will help. But there's also a fourth milestone, and actually Sonia did mention it. At the same meeting of the Conference of the Parties, we decided to examine the option of having a report under the convention. And so there was really a follow-up between the guide, the implementation committee, and then the reporting, actually strengthening as much as possible the implementation of the convention, and also giving material to the implementation committee to perfection their work. Thank you very much.
Thank you very much, and an incredibly helpful way of contextualizing the evolution of historical background and thinking in the matter. Building on that, I think it is, again, a natural next step to look on some of the similar issues, as it were, internally from the implementation committee. Dear Dinara, dear Dr. Zaganshina, the floor is yours.
Thank you very much for this opportunity to talk to you today on this very delightful topic. And I would say we all heard the history of the implementation committee. And I think it's a very important that the convention so much responding to the needs of the countries and come up with all these useful mechanisms and useful soft laws and also mechanisms to help countries. And I will be talking about the role of implementation committee in straightening international law and promoting water diplomacy. And my task now much more easier when Sibyl explained the whole history behind the establishing the implementation committee and the nature of the convention, and most importantly about the facilitative role of the implementation committee. I think it is very important that this role was assigned to the members of the Commission to help in implementation, application, and compliance with the Convention. And by now, the Implementation Committee held 12 meetings, and next meeting will be in coming May. And you can see many members of the Implementation Committee present today, so I'm very happy that we at least can meet virtually. And as Sibyl mentioned, this is a very, very prominent and competent and diverse team of experts. And I really think that it's a team of experts, and it has the combination of different experts with a different background, with the technical background, the legal background, from different regions and from different countries and different, even different generation, I should say. So I think we are very rich in diversity, in serving to the interest of the convention. About the functions, I think it's a kind of the most important part of the implementation committee. It's 4 main functions. By decision of the meeting of the parties, the implementation committee can consider any request for advice from parties or parties jointly on specific issues related to difficulties in implementing, applying, and compliance with the convention. This is so-called advisory procedure. The committee can also consider self-submission by the parties. If the parties decide that it's not able or will not be able to comply fully with the convention, it can approach the committee with to ask for help. And the next possibility triggering the procedure with the implementation committee is the party-to-party submission. When one party or parties having difficulties with another party's difficulties in implementing and complying with the convention. So it's a more kind of, it's a procedure involving two parties. And finally, the committee can consider undertaking a committee initiative when it becomes aware of difficulties of implementation or the possible non-compliance by a party with the convention, including from information related received from the public. I think this is a very important topic, and during the discussion of the implementation committee and preparation of the documents and the whole design of the implementation committee, it was a discussion between the countries of possibility to include communication from the public, as it in Aarhus Convention, for example. But some countries were not supportive to this option, and therefore this framing came up that committee itself can consider the possibility of initiating a procedure if it receives some concerns from the public and after investigation decides that this might be some difficulties in implementation. Also, the committee may examine specific issues of implementation of and compliance with the convention by the request of the meeting of the parties. It can take measures, including recommendations, and it can carry out any other functions that might be assigned to it by the meeting of the parties, including general consideration of implementation and compliance that might be interest of all parties. And in the second part of my presentation, I would like to share with you my thoughts on the role and contribution of the implementation committee to strengthening international law and water diplomacy in general. And I think one of the key contributions of the implementation committee to promoting the water diplomacy is its unique advisory tool, advisory procedure that distinguish it from all other similar mechanisms. Within this procedure, the committee provides a forum for the parties to the convention to get competent advice for any request that they might have relating to the issues related to specific issues related to difficulties in implementing the convention. And also, and I think it's importantly, as we already seen from our first advisory procedure, the committee allows the parties and non-parties, if appropriate, to consider themselves as a collective of solution seekers, rather than defenders of their individual interest or positions. So it's really very friendly, communicative environment between the parties, not reminding us in any adversarial cases that might be held between the parties. And also what is interesting, the committee allows to work at multi-level governance context, which was also evident from our first advisory procedure, when the convention at global level interact with other basin agreements that are concluded between the countries and also bilateral agreements that exist between the countries. And finally, the committee fulfills important role of fact-finding because it can seek information from different sources. And here I would like to share some lessons and some insights that was gained from the first advisory procedure that we just finished recently. In 2020, the committee initiated advisory procedure in response received from the Montenegro concerned about the possible transboundary, possible transboundary impact of the planned construction of additional small hydropower plants on the Sigiavna and Sem River in Albania. Albania immediately consented to participate in the procedure. What the procedural steps the committee took? First of all, the committee gathered information from the countries. It requested additional information from each countries, and then it held separate consultation sessions with the countries and also joint consultation sessions within countries to gather additional information and discuss possible solutions. The committee decided to take a two-track approach to facilitate information exchange that was necessary to gain as much information as possible. And second, to assist in setting up a joint monitoring and assessment framework. And also the committee emphasized that it will be appropriate for this case to take a step-by-step approach from less complex issues towards more comprehensive issues when the countries will be ready to go to more comprehensive measures that they want to take to operationalize their cooperation. And I should say that very specific results were received in very short time frame. The committee advice was accepted by both countries. What was advised by the committee? First of all, it was advised between the two countries, and that was established under the 2018 framework agreement between the countries, should establish a joint technical working group on monitoring and assessment. And if necessary, the members will provide technical assistance in implementing this advice. The second advice was for the countries to develop and implement information exchange protocol to operationalize their cooperation under the UNEC Water Convention, but even more importantly to the bilateral agreement that is in place and which has quite extensive provision on information exchange. And as a follow-up, as I already mentioned, the committee members are available to assist two countries in implementing this advice, both in terms of technical aspects and also in legal aspects. It will be necessary if it will be requested by the countries to assist, for example, in designing information exchange protocol. Another contribution that implementation committee does, it involves and assigns a greater role for non-state actors. As was already mentioned, NGOs and other non-state actors can propose candidates to state parties to nominate. It can submit documents to the secretariat to be submitted to the committee, and it also can provide technical advice to the committee. And very first communication that was received by the committee was received from the public, namely from the Kazakhstani NGO that was expressing concerns on difficulties between the Kazakhstan and Russia in managing transboundary waters on Irtysh River. But after some investigation, the committee decided that there is no ground for initiating the procedure under the implementation committee. What committee also does, and what was, I think, very well explained both by Peter and Sibyl, that the committee contributes to implementation of the convention, very actively participating in designing reporting under the convention, reviewing the reporting and involved in drafting the guide to reporting, but also members of the implementation committee very active in expert and drafting groups under the convention, including the last one on transboundary water allocation guidelines. And finally, implementation committee supports the secretariat in answering questions from the countries interested in accession. I saw the question in the questions and answers box, if the committee can be approached by the non-parties in to ask questions related to accession to the committee, to the convention, I'm sorry. Committee itself cannot be approached by the non-parties interested to join the convention, can approach the secretariat, and if necessary and required, the secretariat can forward question to the members of the implementation committee to help answering question that was posed by countries that are interested to accede to convention. The committee also promotes the implementation mechanism and its use by parties and also non-parties when it's appropriate through communication efforts and specific events as we have today, for example. The committee was active in exchanging experiences with other relevant bodies that facilitate implementation and compliance with other agreements. We had a joint session with the compliance committee under the Protocol of Water and Health and other compliance committees. And finally, it's kind of indirect promotion. We had several members of the committee who were working for joint bodies, and we have exchange of experiences between the different river basin commissions. And here's my final slide with probably a very strong statement, but I think it's relevant that the implementation committee plays quite a unique role in promoting transboundary cooperation and water diplomacy by making use of power of knowledge, persuasion, and dialogue in assisting countries to manage their shared water in a sustainable and peaceful way. And I think that the advisory procedure that we held proves this power of engaging in dialogue. And probably on personal note, I would like to thank two countries, Albania and Montenegro, be so open and friendly towards the implementation committee and also towards each other in designing this recommendation that they will be implementing. Thank you very much.
Thank you very much, Dinara, for the very rich and detailed discussion of the practice up to date. As you heard, there is quite a lot that has happened already, and we hope, of course, that more will be happening in the future. Pedro, now the floor is yours on the role of science, please.
Well, good afternoon. Thank you very much, Martins, for your so kind invitation. Thank you to everybody. It's a pleasure to be here with you. You can see here one of our Iberian transboundary rivers, the Dora River. The first convention was signed in 1867, the second one in 1927, then again in 1964. So as you can see, we have been cooperating very strongly with our Spanish neighbors in all these issues related to transboundary waters. For us, it's very important because more than 50% of the Iberian Peninsula are transboundary river basins. So you can imagine how important it is to both countries. Next page, please. The convention is on water quantity, water quality, surface waters mainly, but also on water uses and infrastructures. Even if there is only one reference to infrastructures in the introduction to the convention, but these are very important because if you want to manage really these waters, you need to have some tools, ways to do it. But infrastructure, as you can see here, two very large dams in transboundary rivers, are both part of the problem and part of the solution, because you can retain water, not allowing it to flow downstream, and you have downstream countries complying that they are not receiving the water that they believe is due. But then again, if you, for instance, if you want to have a flow regime, you must have some ways to regulate flows so that you can really comply with whatever is agreed between the parties. So when you talk about infrastructures, you of course are talking about something that requires scientific skills from some of those involved in this river basins management. And as you can imagine, it's not an easy situation, because when you build such infrastructure, you do it because you want to use this water. In some cases, you want to use this water outside of the river basin where it originates. And so downstream, people will start complaining about it. Next page, please. Well, and of course, water in nature abides only to natural laws that are acknowledged by scientists: law of gravity, of conservation of mass, of momentum, of energy. And of course, these laws, they don't need to be ratified by countries. They are there, and they are the same in Iberian Peninsula, in China, on the moon. These are the same laws. And these are quite complex laws, because, for instance, law of gravity is very important. Flows come from upstream to downstream. If you want to bring them back upstream, you have to add some energy into the process. But and then you have also to add to this complexity, water flows are somehow random. You have seasonality, you have interannual irregularity, and so it's quite a complex task to manage water in rivers, be it national or transboundary rivers. You have floods, you have droughts. People will comply from floods and also from droughts. And you can change from drought to flood in 24 hours, as we have many times seen here in the Iberian Peninsula. I still remember 1995, I was the water director. On the 11th of November, it started raining after a huge drought period, and we had huge floods in a few days. So you have to consider statistical laws also if you want to really find appropriate solutions for the management of these transboundary river basins. Next slide, please. And of course, we only manage what we know. So we have to monitor river flows continuously. This is not an easy task, because you have to calibrate sections, have rating curves. Sections will change because of erosion or siltation. And so you have to go there, you have to use current meters to calibrate these sections, and the next year you go there, and for the same water level, flow will be a different one. You have to go back to further calibration. But this is very important, because you have to have sound data for the management of any agreement between riparians. So monitoring is a starting point for any agreement between riparians, and the engineers will be called to help and provide some information. I must tell you that my experience at some moments, the negotiations, there were only engineers around the table, which of course was not the best solution, but that was it, and we had to deal with it. And then we have climate changes that add complexity to the tasks, because We no longer have completely random processes. We have, in some cases, some stochastic process, which means that the flow is not completely random. It's also ruled by time, and in some cases it's diminishing. And you have to consider this possibility and find solutions to go on with the job. Next page, please. Metering inflows, as I mentioned before, is in itself a complex task. Erosion, deposition of sediments, rating curves need to be regularly calibrated. And also because the rivers are fed not only by rainfall, but also by waters coming from aquifers. Aquifers which themselves are fed many 100 miles upstream in many cases, and you don't really know what's going underground. And so, for instance, the case that Dinara was mentioning, one of the problems is because there are some karstic aquifers in that part of the world, and we don't know if by building some infrastructure you are reducing flow into the aquifers, and the aquifers are feeding river downstream many miles apart from where you built the infrastructure. And so it's not easy. It's very complex. When you have to deal with the groundwater, I usually say that the easy part of the equation is whatever relates to surface waters. Groundwaters, you have to monitor the ground table, where it is, the flux of waters, and you have to resort to modeling, and there is some error in all this that you have to deal with and find the solutions to find an agreement between the parties. Next slide, please. Then it's not them, it's then we have environmental issues, which also require some scientific skills of some complexity. We are talking of living creatures, large species, fishes, birds, but also bugs, because in many cases, if you don't have these bugs, the birds will not be fed, and they will leave the place and try to find another solution. Biologic heritage has to be protected, and this is very, very complex, requiring different category of expertise, and the complexity is such that in some cases, even the language used to express the evaluation of the situation by biologists and engineers, not say jurists and diplomats, is not always the same language. So it is really a complex task that has to be performed. And of course, there is monitoring with errors that must take place. Exchange of information may contribute to reduce these errors, because you can relate upstream and downstream metering, for instance, and so you can promote goodwill for cooperation. The same with the cross-inspection and communication of projects and plan measures. Scientists have a common language, but when you try to present some solutions to jurists and to diplomats, and we have not mentioned diplomats, but they are also very, very important in this dealing with these issues, you have to work hard. Next page, please. So, because of all this, implementation of water conventions requires close cooperation. And I mentioned diplomats, I mentioned jurists, and I mentioned scientists, engineers. Each one of them will bring his expertise to illuminate the way forward. Some solutions are required that, for instance, they may not make sense from a legal point of view, but again, if you want to have less water during winter, more water during summer, Perhaps it's not going to be possible to do it even with some reservoir regulating flow. So teams of experts with all these skills are needed to manage transboundary watercourses and law enforcement. For engineers, 2 + 2 = 4 always, but eventually this is not the case for jurists. I'm an engineer, as you can imagine, and this is a joke I used to introduce in our meetings. So to, let's say, make it go further along. Thank you very much. Next page, just to say bye-bye.
Well, many thanks, and I think certainly the broader intellectual theme of there being nature's laws and human laws is something that has a venerable intellectual tradition going back to ancient Greeks, if not further. So a fascinating and rich array of interventions and also many interesting questions. We probably have about 10 minutes to go. So I think I will exercise my chair's prerogatives and pick a few questions for each of you, and I think with sort of perhaps an expectation of rather prompt, 1-2 minute answers. Could I just also mention to the audience, there have been a number, understandably, requests for slides in light of how helpful and excellent they are, and the speakers have very kindly agreed that they would be uploaded on the webpage. So the webpage will also have bibliography, slides, and the videos, an absolute must see. Let me just sort of mention the questions that I would like to pose so that not to put anybody unawares. I thought I might just ask first a few sort of questions to Yuli. I think a number of questions have popped up about involvement of states as part of the global accession, of states that one might loosely call states contiguous to the Water Convention parties. I think UK, Ireland, and China have been mentioned. To Sibyl, I wonder whether you might have something to say from the negotiating perspective about the interaction between international water law and climate change law, particularly under the Paris Agreement. After that, to Peter, again, there could be no greater expert on questions of Danube that was raised by one of the speakers. And I think perhaps to my colleagues, Dinara and Pedro, in conclusion, whether you have a little bit of a sense on whether there are any regional practices and perspectives, I guess, from your own practical experience. Let me just say that there are also an absolute amount of fascinating questions that perhaps we'll return to in the second panel. We don't have time here. Malgosia Fitzmaurice has always raised a very sharp and interesting question about the role of suspension. There are questions about the character of implementation committee. So I think that I'm sure that Professor Tanzi will pick them up after that. All right, so as I said, rather concise 1-2 minute interventions. Julia, please.
Okay, there have been questions about participation of various countries in the convention activities. So I will start from UK. UK sometimes participates in the convention activities and meetings. Actually, UK was very active in the legal board when the legal board was negotiating the implementation committee. Ireland, no, they do not participate in the meetings under the Water Convention. And then there was a question about China. China actually participates quite often in the meetings under the Water Convention. So there was a large delegation which took part in the MOP 8 in Nur Sultan. They also participate to the other meetings, and they increasingly have an interest towards the convention. So for example, China translated into Chinese several guidance materials developed under the convention. For example, the guidance on the identification of benefits of cooperation. And in general, we are trying to play more to put more emphasis on Asian countries. There is a dedicated person in the Secretariat who works with Asian countries who might be potentially interested in accession, and especially with Vietnam, who actually expressed official interest in the Water Convention. And there have recently been 2 webinars organized for Southeast Asia countries and for South Asia countries to promote the convention. Thank you. Over to you, Martins.
Thank you, Julia. Sibyl, please.
Yes, thank you very much. Well, actually, the Water Convention has a task force on water and climate adaptation to climate in transboundary basins. So we do work with actually the UNFCCC. We are very involved actually with them with the Green Climate Fund. We also have done with the World Bank a very joint efforts on financing in transboundary basins for strategies on climate change and water. So we are fully involved, and we've had just a few weeks ago a workshop, a global workshop on water health and climate change, actually a joint venture between the convention and the protocol. And we also encourage very much countries in their NDCs and NAPs to put water very high on the list, and also transboundary questions. So we are fully involved actually on this topic with all the possible partners you have at the moment. And we are very glad also of the partnership. I have to say also the World Bank has come up also with a very good brochure that we did all together on financing climate strategies in transboundary basins. So we are working very much on this. And there's also a global network of basins that are dealing with this topic, and we are inviting new basins to actually join. So you'll find everything under the climate change part of the website of the Water Convention.
Thank you, Sibyl. Very helpful, very informative, very concise. Peter, off to you for Danube.
Yes, thank you, Martin. I think it's very interesting this question, because Danube is well known. I believe in all over the world as a most international river basin, which has one of the most efficient river commission working on. I also had a pleasure to be served as a president for the ICPDR just 2 years ago for a 1 year period of time, and I also leading the Hungarian delegation. And I can assure you that it's really a good exemplar. And itself, the Danube Convention was built on the provisions of the Water Convention. If you're comparing the two documents, you will find many identical things in both of them. And it's really important that it's a very good exemplar how the countries can collaborate with each other. And the Danube is the best case because it combining, let's say, the most wealthy countries in Europe and the most poor countries in Europe, and unifying those countries under the objective of a joint management of the water bodies. And it's really great success in that field that we were able to elaborate a joint river basin management plan, which is covering the whole basin, and also a flood risk management plan, which also entirely covering the basin. And those results, and also we taking up new tasks like climate change. We just renewed our climate change adaptation strategy in the Danube Basin. And one of the advantage of the Danube cooperation that we are 14 countries plus the European Union who are the signatories, and we are speaking at least 12 different languages. So the main communication is on English. So all the publications, all the supporting materials can be found on the website of the ICPDR. And through the English, it can be utilized, let's say, most part of the world very easily. Thank you.
Many thanks, Peter. And to Dinara and Pedro, I suppose sort of the same general question as I posed about the slight tension, if any, between global and regional. Is there anything, I suppose, peculiarly Asian or peculiarly Iberian in transboundary water practice that you have come across in your experience? Dinara first.
Thank you. I think for us it's a bit more easier because Central Asia has been always a part of the UNEC region. So with the opening of the convention, we still were in the pan-European region and working quite closely with the convention. I think all countries, even non-member countries, were participating at regional projects. And I think within convention itself, we already see these regional practices in developing different tools and guidelines and projects on Nexus, on Sirdarya River, for example, and even now establishment or transfer of International Water Assessment Commission to Nur Sultan, which now focusing on Central Asia and neighboring countries to Central Asia. So trying to expand the region to other regions, also including China, because Kazakhstan is has riparian countries with the China, which also involves the possible connection on that. But still, I think there is still a lot of room for improvement for all of us, both on the convention side, on the implementation committee and the countries, to promote better convention and implementation mechanism in Central Asia and Asia in general. I think now we see the trend that convention gets more popular in Africa, which is very good sign and very promising. But we can also do the similar push in the Asian direction. And all we as a community of lawyers and a community of water promoters, water cooperation promoters could be more proactive in showing the benefits of the convention and implementation committee. And again, going back to the last advisory procedure, I think it's a very good example of very friendly cooperative, cooperative spirit of the countries and implementation committee members in designing the recommendation that was accepted by the countries. And it's clear sign that there is no allegation of non-compliance to the parties. It's just advice that can benefit from. And it was the question in the chat box if we need to establish similar implementation committee in Central Asia at the basin level, for example. I would see more benefit in applying to already existing committee, which has a wide experience and probably some neutrality and some distance from the region, which can provide more benefits for the countries. In this sense, it does have more similarities with the core principles of mediation. There was another question asked in the question and answer box, if there is a similarity. So indeed, this neutrality and impartiality in the mediation we also can see in the implementation committee. Thank you.
Many thanks, Dinara. Pedro, I think the same natural laws apply on Earth as on Mars, or was it Moon? But so what would be your take on the regional global tension?
Well, I don't see such a tension because wherever I've been involved in these kind of negotiations, namely quite recently in the Dniester River Basin, people were looking both to the Helsinki Convention and to the New York Convention. And both conventions were being considered as a good basis for the negotiations that were going on. And today, in the morning, I participated in a webinar with the people from this commission, from Moldova and Ukraine. And they are doing quite well. And I could see that it's a good spirit. On the other hand, I was also in Africa, helping and supporting Mozambique in its negotiations with South Africa and Swazilandia for the so-called Nkomati agreement, Nkomaputo agreement. And in that part of the world, there is a regional convention, which is based on the New York Convention. It's a protocol, water protocol. And they were working very, very hard to find a solution that could be acceptable to all parties. But then there was an issue, the issue that Peter mentioned of water sharing. And this is one of the difficult points in any negotiation. Let me tell you, in 1998, when we finished this Spanish-Portuguese convention, Mr. Antonio Guterres, whom you saw just a moment ago, Secretary General of the United Nations, was Prime Minister of Portugal. And he who signed from the Portuguese side this convention in Albufeira. And the agreement on water sharing came in the last minute. The people were already in the room, the people from the newspapers, and the document was prepared to be signed, but the prime ministers had not yet agreed that they were going to sign it. But finally they decided to sign it. It was very important. So the two documents are very complementary. You can find solutions more specific for this or that river basin, for this or that situation, but that's all. Thank you.
Well, many thanks, Pedro. And I think that if there is, I was absolutely fascinated by Pedro's concluding joke about 2 + 2 not being 4 for lawyers. And I do wonder whether a slightly reciprocal joke would be that for lawyers 2 + 2 is 4, but then engineers will tell us that that is silly and will never work in practice. But I think the positive takeaway of this is that lawyers, jurists, engineers, diplomats, scientists, NGOs, the bigger community may have slightly different takes on these things, but if we talk to each other within the same body, within joint bodies, that can only improve the quality of our engagement with these very important issues. Let me, unfortunately, we cannot applaud. I'm sure it will be thunderous applause if we had an audience, but it has been an absolutely stellar panel.
Well, thank you all very much. Thank you, Martins. I'll do my best to keep the second panel up to the standards of the first one, but I'm sure that I'll be helped to that end by the first-class speakers that I will be keen on introducing in a second. Again, many thanks to Lisa for the technical support. And many thanks to those who have found the time to connect and be with us. I'm going to speak for about less than 10 minutes. Because thank God, most has been said by all speakers in panel one, including by Sonia in her introduction. So I can cut my introduction very short and pass on to the most interesting part of panel two. But all these historical background, the accounts given by the previous speakers, very friendly and well-known faces, including Sibyl, with whom we fought some friendly battles for a good cause, made me think of the good old days when we concocted the implementation committee, and we met some difficulties, and those difficulties taught us a lesson, and perhaps may help us to best appreciate the rationale and the further potentials of the committee. That was about 15 years ago. There were indeed difficulties for a number of delegations taking part in the legal board, which expressed concerns about setting up such a body. The main arguments against were based on the lack of an explicit provision grounding the actual setting up of the committee, differently from explicit language in the constituent instruments of other bodies of the kind, including, for example, The closest to ours, the Compliance Committee of the Protocol on Water and Health, just to mention one. Now, the issue was not one of legal formalism, as the lawyers in the delegations who objected to the project knew full well. It was diffused practice whereby conferences and meeting of the parties had established subsidiary bodies deemed instrumental to the pursuit of the aims of the convention. The legal rationale for this would be the usual implicit powers or functional doctrines, as it were, which, as a matter of fact, would not be addressed extensively, usually in diplomatic discussions. There was a discussion, in fact, as clearly singled out by Sibylle de Vermont during the first panel, in our case, because Article 17, a rather peculiar and very helpful provision, to use an oxymoron, explicitly endorses implicit powers doctrine. As recalled by Sibylle, it vests the meeting of the parties with the power to, and I quote, undertake any additional action that may be required for the achievement of the purposes of this convention, unquote. And there came out the committee as a matter of legal procedure. But aside from the legal procedural issues, and before we got to their successful solution, perplexities and objections in some cases were of a more substantive character. One would call them political concerns, which would eventually be overcome by dialectical persuasion when possible, and eventually by counting head. The main substantive argument against having an implementation and compliance review body was that the drafters of this particular convention purportedly avoided envisaging one because the provisions of the convention were allegedly not suitable for implementation and or compliance review. The point was made by some that by stemming from a convention having a framework nature, and this is certainly not the only one, its provisions were deemed too general or in any case unsuitable for review. This argument was reminiscent of the view held in the legal literature at the beginning of the 20th century, particularly in North America, whereby transboundary water disputes would be unsuitable for being treated by means of dispute settlement other than negotiation, let alone adjudication. As we know all too well now, dispute settlement practice to this day, including adjudication, has abundantly disproven this argument. Be that as it may, we even sidestepped addressing the actual concept of disputes during our discussion in the legal board. It was political and pleasant to some, except that we made reference to Article 23 of the Convention, which provides for optional adjudication and arbitration. These allowed us to argue, by contrast, that the proposed mechanism would be way different from any procedure of an adversarial nature. Most importantly, our a contrario reasoning helped us to move away from the concepts of wrongfulness and the ascertainment of international responsibility. Terminologically, we even moved away from the concept of compliance and compliance review as such, so as to get closer to implementation assistance. There was a favorable circumstance at the time, which has been recalled a while ago. And the favorable circumstance was the discussions within the legal board and the rather exacting endeavor of putting together the guide to implementing the convention. It is a long but inevitably general document meant to assist parties in implementing the convention, but general and abstract. It also catered to states potentially interested in acceding to the convention, giving them an idea about legal, administrative, scientific, technological, and financial duties and benefits thereto. Fact is that the production of this instrument of guidance had been prompted precisely by non-states parties requesting the convention governing body, the Bureau, to shed some light on the way forward for them in order to accede. Inevitably, as I just said, the end product was not tailor-made. Intergovernmental subsidiary organs made up of state representatives, such as the legal board, would appear unsuitable to address concrete requests for assistance on a case-by-case basis. And there, the proposal was put forward to create a new agile body made up by independent experts versed in water law, diplomacy, and science, which could provide with such assistance on demand and facilitate implementation, and therefore, by doing so, facilitating compliance. And the instrument was drafted in such a way that the main focus would be primarily on implementation and compliance facilitation and assistance, more than on review and sanctioning. This accounts for the prominent role given to the rather original advisory procedure, which has been mentioned during the first panel. The fortunate character and appropriateness of this facilitating advisory function seems to be corroborated not only by the successful outcome so far of the advisory procedure between Montenegro and Albania, thanks to the impeccably cooperative conduct by the two states. It is also notably corroborated by developments with regard to the fellow body, the Water and Health Compliance Committee. In 2014, it somewhat integrated its functions with the procedure very close to the rationale of the Implementation Committee advisory procedure. There, with the endorsement of the meeting of the parties of the protocol, it adopted a form of consultation procedure with a view to, and I quote, assisting the parties in implementing the provisions of the Protocol on Water and Health, unquote. It focuses on advice and assistance to be adjusted to the needs of the party involved, and it can address scientific, technical, legal, and administrative issues. Interestingly, by way of some kind of tacit cross-fertilization, while we don't have a communication from the public procedure in our implementation committee, as a matter of fact, communications from the public may well be taken into account within the framework of its information gathering, necessary prerogative for the purposes of pursuing other procedures, including a self-triggered procedure. On this note, by way of conclusion, I may recall the first time we looked into what might involve the triggering of a procedure. And it was prompted by information sent to us from a Kazakh NGO. Addressing that information in combination with other self-gathered information, including partly from interested countries, eventually the committee decided not to proceed. However, we had the opportunity on that occasion to make a general statement which was endorsed by the meeting of the parties, which I regard of significant importance, which pertains to the relevance of the relationship between procedural and substantive obligations in our field. One of the countries in question replied to one of our questions that there could not be problems of implementation of and compliance with the convention because the co-riparians concerned were fully cooperating with each other. That gave us the opportunity to stress that cooperation is not an end in itself and would not be a license to disregard the substantive obligations of due diligence in harm prevention and of equitable and reasonable utilization of transboundary waters compatible with environmental sustainability. Well, I think that is about all for me to say by way of introduction. The most important introduction I have to make is of the panelists. And we have the best we can possibly think of in our field, starting from Professor Malgosia Fitzmaurice, who is a generalist who addresses so many specific bodies of international law, including water law. And I remember Malgossa's writings were in the forefront of this field, both with regard to the transboundary dimension and the right to water as in its human rights dimension. Catherine Brolmann, professor of international law, very much at the University of Amsterdam, very much versed into the non-governmental side of management and policy, water policy issues. Ambassador Jimena Fuentes. Jimena, apart from being an ambassador, is a first-class lawyer and a first-class water lawyer. I remember her PhD dissertation water law under the supervision of Professor Ian Brownlee in Oxford. And I remember looking at her writings on the British Yearbook of International Law in this field. And she is now applying her science and knowledge as the head of the Directorate of Boundaries and Border Areas of the Ministry of Foreign Affairs of Chile, and currently being the agent for Chile in the case before the International Court of Justice on the status of and use of the waters of the Silala. Alejandro Isa, an old friend and an old water law friend from IUCN, Environmental Law Program. We have with Alejandro, and I remember also with Jimena Fuentes, engaged in an effort, in the first effort for promoting the Water Convention outside Europe, and that was in Buenos Aires. Don't make me remember when, but it was a while ago. Professor Makane Moise Mbenge from the University of Geneva, we met, don't make me say when, but it was long ago when you were very young. And it was precisely on an international water law issue. It was in The Hague when you were attending a seminar by the Center for Research of the Hague Academy. And I was presenting a book on water law. Christina led from the World Bank, and she got into the World Bank after having developed her water law studies. And we were to be meeting officially in your capacity as a legal officer there with the implementation committee just when we had to cancel in-person meeting and the pandemic broke out afterwards. Last but certainly not least is Professor Christina Voigt from the University of Oslo, and very pertinent to our discussion is co-chair of the Implementation and Compliance Committee of the Paris Agreement. Now, differently from the first panel, we are not intending here to have a structured list of presentations. We would like to keep it in interactive and colloquial terms. I may initially elicit a virtual round of the table discussion on 3 general questions, and then I may ask you to keep your initial remarks within 5-minute limit. After that first, we can have exchanges amongst yourself, and I may be taking questions from the audience. With Martins and Steve, we thought of a discussion revolving around 3 major themes. The first one on the implementation committee, in comparison with other treaty bodies of the kind, stemming from multilateral environmental agreements, both comparative considerations and sort of non-technical least pendency issues. The second theme would be the relationship between the implementation committee and other means of international dispute settlement applicable to water disputes. And finally, if we'll have the time, we'll address the issue of the actual and potential relevance of the Implementation Committee for research and teaching purposes within the framework of international water law, environmental law more generally, and the law of dispute settlement. I would give the floor for a first statement concerning our first theme to Professor Malgosia Fitzmaurice, who has been a keen supporter of our committee. I may remember that the first meeting of our committee outside Geneva was held in London at Queen Mary Public Law Department under the kind invitation of Professor Fitzmaurice. Happy to be back in London virtually and very glad to have you with us. You have the floor, Malgosia. You have to.
I am okay now, I think. Can you hear me?
Very well.
Yeah. Thank you very much for also inviting me to this really interesting seminar. And thank you for giving me the floor now. So this is the, as you said, first theme, which is sort of generalities between your implementation committee and other similar bodies of multilateral environmental agreements. I will not take much time because there are many distinguished speakers, but in preparation for this intervention, I sort of looked at other, let me call it compliance bodies, although you really don't like this term in implementation committee of the Water Convention, but if we go traditionally to Montreal Protocol, we see that it was still non-compliance or compliance later committee. So I would like to start with what Tullio Treves said, that if we look globally, all these implementation bodies look the same. But when we make a very detailed analytical approach, we can see that they differ to a very great extent. And I kind of grouped it in, for instance, how these compliance bodies are set out. So, for instance, each and every treaty, I think, tries to make a compliance or implementation body which would fit the character of a treaty. For instance, Aarhus Convention, which is a hybrid treaty between human rights and environmental law, has a very much compliance body, which is directed at bringing in lots of non-governmental entities and the public. So even if we look at the stage one, how they were set up, we already see great differences. So they are so-called enabling clauses, which are very, very direct, like in case of Montreal Protocol, which has in Article 8 this enabling clause, which was ground for setting up the first compliance committee. Then we have, I would say, a clause of a general character, which was already mentioned in relation to implementation committee of Water Convention. So Article 17 to F, which gave implementation committee was based on general function granted. And then we have few examples when the implementation body was based only on the decision of the COPS-MOPS, which is the Basel Convention on transboundary movement of hazardous waste. It was no enabling clause, non-general enabling clause. It was only the decision. Obviously, as a generalist, and I wrote about it quite a bit, it raises question of legitimacy, which is of course, a greater dimension, also looking at theory of international law, the question of legitimacy and of course, issues of general issues of the law of treaties, question of consent to be bound, which is what particularly interests me in relation to these committees. Then we have, I set out a question, identify of powers of this implementation bodies. So it is mostly a facilitating mechanism. And I would really say that the advisory faculty of implementation committee in Attila, in your committee, is absolutely fascinating. And I think that it takes facilitation a step further than just normal facilitation of the implementation committee. So I would really, in particular, single it out as a means for states to ask for advice and help without pointing a finger who at a state who may be not in compliance. So I think it is a really useful, if not really wonderful facility to help states to achieve a means of complying. And it's absolutely voluntary, and it's also based on consent, I understand. So it really goes beyond normal advisory facility. If we look, for instance, at the ICJ, it just is all based on consent, voluntary participation, and involvement of implementation committee to help and assist. So I really would commend this kind of solution in relation to facilitating compliance with MAA. Now, I would like to, in the framework of this, I would like to mention that there is, of course, one quite unpleasant mean, which is suspension in rights and obligation of the party to a treaty, which obviously also I teach in my law of treaties class, whether it's material breach of a treaty, general, or because it's based on general rules of international law or state responsibility. However, this is, I would say, an older approach, because we knew, for instance, implementation mechanism in POPs Convention, and I think Christina will have to help me in Paris Agreement. There is no such a facility as suspension. No, exactly, in rights and obligations. So it's, thank you. So it's purely a facilitative approach, new approach. And I wonder why this suspension still found a place in means in implementation committee, because it's such a state-friendly and facilitative committee that I don't think it has a place there, honestly. However, just to briefly say, in the CITES Convention Compliance Committee, the suspension in trade rights, it's a very common means. And I checked it out for something I was writing now. It's about 60 states were suspended in trading rights. And it is still very used. But I would say that unlike the convention, the Montreal Protocol, the Aarhus Convention compliance, it doesn't rely on general rules of international law in suspension, but only on convention and recommendations of COPS MOPS. So this is the difference. Well, I would also say that I would like to say that, again, I think that to wind it up, that the implementation committee of Water Convention is really a step forward due to this advisory facility. And I think that other new implementation / compliance mechanisms should take an example, because I think states are more willing to come for help and assistance if they don't have to be sort of, well, put in an unpleasant position of being stated of being in non-compliance. So I think that this advisory opinions facility in implementation committee, it's something which I find extremely positive step forward and something which should be followed by other similar bodies. Thank you very much.
Well, it's me who thanks. Thank you very much, Malgosia. That was, as anticipated by Martins earlier, a very sharp and comprehensive series of remarks that hit the mark on each and all of the points you made. I'm pleased that you emphasized the facilitative nature of the advisory procedure, because we international lawyers, we have to think of an international advisory procedure. We think of something very loyally being performed by the International Court of Justice, in which it is to state the law, and we are not there just to state the law, but rather to, or even to state the law. We are there to facilitate conduct of the parties in complying with the law, not necessarily applying, legal issues. And interestingly, as a matter of practice, with Albania and Montenegro, we were not requested, and we are not requested to state the law as such. We are there to facilitate the parties to conduct themselves in the best way possible according to the aims of the convention. As to the suspension and rights and obligations, I agree with you that this is a bit out of step. It looks out of step, it does. And I doubt whether it will ever be applied. But it was a tremendous political success in terms of negotiations and bargaining, when you consider that some delegations didn't want to hear about anything concerning third-party involvement in the issues concerning compliance with the convention. So it is there. It's the idea of the stick next to the carrot, which hangs there, but will probably and hopefully never be used. But thank you very much again, Malgosia. I would ask immediately Christina, Professor Voigt, if you can give us your take of this animal of ours with respect to the big animal of yours. We are a tiny mouse. You are a big thing. So please, you have the floor.
Well, thank you, Attila, for kindly inviting me. It's a great pleasure being here and listening to you describing the process around the implementation and compliance committee under your convention, but also listening to Malgosia. We know each other well, but it's always a privilege and a pleasure listening to your overarching comparative analysis. So thank you very much. Well, as you already mentioned, I'm the co-chair, the inaugural co-chair of the Paris Agreement Implementation and Compliance Committee. And you may be right that it's a big animal, but it is a very young animal. It's a very fresh one. And I have made the experience that it's not so well known yet out there in the world, or even amongst the parties of the Paris Agreement. So I would like to say a couple of words about it, and then I come back to some of the comparisons with your implementation committee. As you may know, the Paris Agreement Implementation and Compliance Committee was already established in the Paris Agreement itself in 2015 when it was negotiated, which means that it was part of a very huge compromise, as you can imagine. Just getting the Paris Agreement in place was an enormous task, and fitting in the Compliance Committee in that architecture was actually quite an achievement. I did negotiate this aspect. I was the legal advisor and negotiator for Norway. And it was quite a surprise that we did end up with a compliance committee, because similar to what you said, Attila, there were many countries, states that didn't even want to hear the word compliance in the context of the Paris Agreement because of the Paris Agreement's character as being this bottom-up, facilitative, procedural agreement, where the idea of compliance doesn't really sit very easily with this bottom-up nature. That was the view of many parties. And in the end, it was really only a handful of parties who insisted that we need a mechanism, including a committee that looks at whether parties actually do what they said they would do in terms of the very few legally binding obligations under the Paris Agreement, capture that under compliance, but also has a facilitative nature in order to facilitate and enhance implementation. So it actually does have both elements equally represented in its mandate. Now, the committee members were only elected in 2019 at the last climate COP we've had so far, not in Chile, almost in Chile, but Chile as the host together with Spain. And since then, we didn't have, of course, a COP until now this year in Glasgow. And the first meetings of the committees only happened last year and this year, and only virtually. So the members of the committee have never met in person. They've only met in this virtual world, which is of course a challenge, because our first task now for this year is to finalize the rules of procedure for the compliance committee, which are supposed to be adopted in Glasgow this year. So it's a very young committee. That's what it's like, a baby committee compared to yours, and we've just taken our first steps. But the parties to the Framework Convention on Climate Change, they considered implementation and compliance very central to the effective functioning of the Paris Agreement. And they put it, as I said, within the overall architecture of the Paris Agreement. Now, the committee consists of 12 members and 12 alternates, but we currently have 4 vacant seats. And the nature of the committee, as I already indicated, is facilitative, very similar to what you said, but it has no mandate to apply sanctions or penalties. That was part and parcel of the overall compromise. Parties were only willing to agree on a implementation and compliance mechanism if that mechanism was not having any really hard teeth. That's part of the compromise that we had to accept. There are no party-to-party triggers or submissions possible, and no submissions by the public. There are only 4 ways of how the committee can engage. One way is that a party can always come to the committee with own challenges on implementation or compliance. The second one is that the committee by itself, without the consent of the party, can take up issues of non-compliance. And they are really defined and identified in the decision from Katowice in the rule books. And these are the concrete core legally binding obligations of parties under the Paris Agreement. And if a party does not comply with them, the committee will take up this issue, and there is no discretion and there is no consent requirement. The fourth possibility is that the committee can link up to the transparency framework, which hasn't yet kicked into motion under the Paris Agreement. So that's something for the future to watch. And the fourth element, and that's maybe something I wanted to discuss with you, Attila, is that the Implementation and Compliance Committee under the Paris Agreement has the mandate to look into systemic issues, which means if it in its work realizes that many parties are facing the same challenge, that indicates there's something systemically wrong or not quite functioning under the Paris Agreement. And then the committee can bring this issue to the attention of the governing body, which is the CMA, and can also bring recommendations of how to address systemic issues. So we have a very detailed, defined mandate, but it is both facilitative, enhancing implementation, but also promoting compliance. But the measures are fairly limited. We have not all the entire toolbox that you have. I think the most stringent measure that the Compliance Committee can adopt is to issue a statement of facts. No statement of non-compliance, let alone any suspension of treaty rights. I think I stop here, and I'm happy to discuss this in more detail if there's any interest in it.
Thank you very much, Christina. There will certainly be interest. I mean, we know how the world, all layers of the world, are so focused on that agreement and how important it is for the sustainability of the planet that being part of compliance implementation review processes is a great duty, and I think and a privilege, of course. And I suppose that, as you said, having the establishment of such a body within the overall negotiating package shows that eventually those who committed to the process really committed seriously, because it is such a delicate issue that submit themselves to compliance and implementation review means availability to be scrutinized. As to your question, and then I'll pass on to the next speaker, Christina, is your question about whether we have any powers or competence concerning the possibility to address systemic general issues. We are very much dependent on the meeting of the parties, and there is an open clause whereby we may act according to requests from the meeting of the parties, which may ask us to get involved, including in a number of issues, including of a general character. One of the exercises which has occupied our time during the previous mandate, I believe, there was a pilot reporting procedure, and we assisted the Secretariat in monitoring reports coming from states and about difficulties, about what they recorded about their record of compliance, and that was certainly a general and systemic task which we performed. Well, thank you very much again, Christina. Let me jump onto the non-strictly intergovernmental dimension by way of alternation, and then we'll get back to certainly the intergovernmental and perhaps even interregional regional dimension. But let me turn then to Kiki Brolmann and Alejandro Isa in succession. Kiki, you are a great specialist of the multi-layered international community in non-exclusively governmental terms. How, from your standpoint, from the standpoint of your scholarship, do you regard this committee of ours, and in comparison with like bodies? Please, Kiki, you have the floor.
Yeah, I'm a bit overwhelmed with this credit you give me for being the connoisseur of the multi-layered international community, but let me first 1 second. Yeah, this is a bit better. So thank you very much for having me. Thank you for the wonderful conversations and insights so far. How do I look at the implementation committee? I had to really read up with great pleasure, but I had to do that, and I thought I did think it was quite special for this advisory function, for example. But a lot has been said already on the institutional structure, so I will not try and follow up on that. But I was struck by the fact that on the one hand, it is so rigorously interstate. So in a way, it's very old-fashioned. You almost get a whiff of upstream, downstream states struggling, and then they can go to a committee, and nobody else is allowed before the committee. So that is the first. But then you see this committee's initiative with the where the public involvement has been sneaked in, which I thought is a brilliant solution. But I would love to hear more about that actually from the connoisseurs of that multi-layered process. And so that I thought is very interesting. And then of course, as has been eloquently put forth already, the functions of the committee and the measures it can take, they are so subtle, and they cover they are not binary as lawyers like to see it, but they cover a whole spectrum of, and they are like nudging and a bit of carrot and a bit of stick. And I think it is, I agree with Małgosia, or I find it plausible that this should be used more often. And I was also thinking, maybe for now, I then leave it at that. I was also thinking that in a way, it is the future, a bit tying in with what Małgosia said also. I wrote 2 years ago or so, I wrote a little piece on the SDG 6, comparing SDG 6 with international water law. And then, of course, we know that much of the substance of the various areas of international water law exist in a disconnected manner, and it's hard to bring them together as lawyers and making your case and everything. And on the other hand, all these areas are connected conceptually by the framework of SDG 6. And SDG 6 addresses states and audiences and everybody and everything, basically. And it is comparatively general, and it is inclusive qua norm addresses, as I said, and qua territorial scope. So of course it's not legally binding in the way of a treaty, but then again, as everybody is starting to think, maybe the binding treaty is not the biggest tool of all anyway. So I think, to wrap up, I think the committee is splendidly prepared for the 21st century with this sort of holistic way of operation. But for me, it was really, I admit that it was new. So this is a bit of a first-hand impression, but I really like it. It's very interesting also.
Well, thank you very much, Kikins. It's encouraging to receive your positive comments. And you, I think you're absolutely right in looking at these little spots. There's a satellite in the international environmental law galaxy that, despite its black letter configuration, it allows for some degree of integrated approach to be looked at. And from a pragmatic standpoint, even if we do not have a submission procedure or communication procedure, as it were, we certainly take note of information coming from the public in our information gathering process. Nothing prevents us from doing that. And we have already done so in the past. We have transparency procedure rules. We welcome observers from the public. And so we're a pretty open body that will do our best to meet the challenges of these difficult centuries, you say. Now, Alejandro wears sort of both hats. He's a bit of an NGO representative and an holistic intergovernmental soul that pops up with us and can be flexibly interpreting multifarious roles. So I'll be very keen to hear your views in wearing whatever hats in some kind of magical performance, and you have the floor, please. And unmute yourself, please.
Thank you so much, Attila, and thanks for inviting me to that. So let me see if I can say something sensible in this fora, you know, surrounded by these distinguished professors, academics, and people that are really working on these issues, specifically on this committee. Generally, what I would like to think about is the role of these committees in promoting the effectiveness of international law, international environmental law more broadly, and how they can help to deliver fairness, equity, justice more broadly in terms of natural resources management. We're talking about water. And I'm working in promoting law and equity and fairness in a nature conservation organization. And I see one particular role and one distinctive role, of this committee. So when receiving submissions on non-compliance issues, these bodies can conduct, as we heard before in the first panel, especially investigations in a non-controversial way, foster implementation through mechanisms that can bring together different interests at issue. And this is, I think, an important point of departure, considering that environmental law as such and in general is based on consensus building, creating enabling conditions, for countries to cooperate. Again, on water is very prominent, that role of creating the enabling conditions for cooperating, especially when we're talking about transboundary settings, and to find solutions at the end of the day on more broadly on planetary challenges. And I think that through these consensus-oriented mechanisms, one can promote, the much desired effectiveness of this body of norms and principles that we understand and we call international law, international environmental law, and international natural resources law. Again, and also from the point of view of the non-state actors, I personally see the Water Convention Implementation Committee as one interesting tool, possibly a very effective tool to ensure that civil society individuals, civil society organizations, and other collectives to participate, allow their participation in the implementation of an international agreement, as they can certainly, as we've heard, submit information to the committee and as such, provoke that the committee can take an initiative and raise the matter as part of its implementation mechanism. So this is my take, from this mixed aspect of governmental, non-governmental organization, great potential, especially in terms of, as I said, the non-state actors' role in securing implementation of international environmental law.
Well, thank you very much, Alejandro. I think I fully agree with what you said, and we'll put that absolutely to fruition. Thank you. We heard earlier this afternoon
You're muted, Attila.
Sorry, we heard this afternoon reference to, in the introduction by Sonia, reference to the regional dimension. One of the richest area, I mean, we are all rich with water, but certainly Latin America is impressive with the amount of transboundary water they have and the tremendous practice they have, but also their reluctance to join multilateral frameworks. And I would kindly ask Ambassador Professor Jimena Fuentes to elaborate on that and see whether from her standpoint, compliance bodies in this field would add value to existing institutional joint institutions, water bodies, or what. The Latin American impression is very important. And I look forward to hearing your views, Jimena. Please, you have the floor.
Well, thank you, Attila. It's I'm very happy to see you. I don't know when was the last time you were here in Chile. I think 2 years ago.
Yes.
Before the COVID pandemic.
Under your kind hospitality.
Yes. I'm glad that you remember my hospitality. I put a lot of effort on that.
Very much appreciated.
And I would like also to thank Dr. Martins Papanarikis for the invitation to participate in this seminar on the implementation committee of the UNEC Water Convention organized by UCL. Well, Latin America, you are right. The number of shared water resources is huge. In some areas, there is a lot of water, but on other areas, water is becoming more scarce. And we have so many different climates in Latin America. So I look with great interest the implementation committee of the UNEC Water Convention, because it might be an alternative to promote the resolution of water disputes. Sometimes states are suspicious or about dispute settlement, or they don't like the confrontational aspects of dispute settlement. Now, as we were making a comparison here between implementation committees on other treaties, such as the global environmental treaties or the multilateral environmental treaties, and this one, I thought in bringing some or trying to identify certain elements which I think explain why implementation committees might work differently. And I think that one of the important factors to take into account would be the fact that global environmental treaties deal with global concerns, such as the ozone layer, such as climate change. But water conventions deal with very, I would say, close because they are physical environmental impacts between neighboring states. So the difference lies on the fact that global environmental treaties deal with problems in which the responsibilities are shared by so many countries. And it is not clear the share of responsibility that each has to bear. There is a problem, I think, there in establishing the causal relationship between the activities of one state and the resulting environmental impact. But in the field of water resources, the environmental impacts between neighboring states, I think, are clearly the result of the actions of some of the riparian states. Therefore, there is the chance to be able to identify the source of the potential harm. Therefore, causality is a relevant factor that I think would allow to distinguish why implementation committees work differently in each of these areas. The implementation committees established under global environmental treaties then are an alternative, I think, to traditional dispute settlement mechanisms, because dispute settlement mechanisms would be quite ineffective in that area, in that environment, if we consider that there is an enormous lack of first information and also difficulties in establishing the extent of the contribution of each of the parties to specific impacts. But in the case of shared water resources, as I said, here causality between activities by riparian states and harm on the other riparians at least in theory, can be established. Therefore, as a matter of scientific evidence, at some point, you could blame some of the riparians for the impacts that others are seeing on a specific water courses or even groundwater. Therefore, here it might be that states would prefer implementation committees of the sort of the implementation committee of the Water Convention, not as a replacement for dispute settlement. Dispute settlement mechanisms will always be on the backstage, but it will be a useful tool to, for example, to collect information, to collect data, and also to obtain expert advice. Because in my experience, dealing with boundaries and frontier zones in a Latin American country like Chile, where we have a very, very long border with our friend Argentina, and Alejandro is here, so he knows what I'm talking about. So we have very many shared water resources. And one of the things that we would like to obtain probably before entering into conversations is information, data. Therefore, I think that in this context, implementation committees might help the riparian states to obtain information in order to help them to comply with their international obligations before the crystallization of a dispute. So I think that that is one of the main differences that I find between an implementation committee such as the one that has been put in place in the UNEC Convention and implementation committees in the context of global environmental treaties. Thank you.
Well, I thank you very much, Jimena. And I think you also hit the mark, the way I see the mark, in the sense of the compatibility or perhaps even integrated approach to non-adjudicative, the non-adjudicative role of the implementation committee and adjudication. It is formalized in our constituent element in a without prejudice provision, which says that this committee procedures are without prejudice to Article 22, which provides for adjudication and arbitration. And you're right, if well, the curtailing of the dispute about facts, where you have such geological, hydrological, scientific issues at stake, are very important to be determined objectively, and certainly the committee may help to that end, and we would remain flexible in trying to provide, I suppose, complementary assistance. And for one reason, we think we are suitable because we have many scientists in our committee. So we are a mixed composition, promoting interdisciplinary cultures, which is not easy, as you certainly know in your legal teams. So thank you very much, Jimena. We came from one regional dimension, and we'll pass on to the African continent, where we have a great environmental water law scholar who, next to be a definitely authoritative scholar, has tremendous practice already on his hands, having even nearly burned his finger, or being brave enough to put his hand into a very, very hot spot of Africa, such as the Great Renaissance Dam, as officially a coordinator there. Professor Makan Mbenge, you have the floor.
Thank you very much, Attila. Good afternoon to everyone. I'm really happy to be here, and it's great to see colleagues and friends that I haven't seen for a long time. So thank you so much to you and Martin for this invitation. You know, Attila, when it comes to the African practice, I think there is a paradox, because when you look at the vast constellation of African water agreements, you will see that they have been very sophisticated in establishing water organizations, river basin organization, river basin institutions. But there is a paradox, because when you look at provisions in those agreements dealing with dispute settlement, usually those provisions are rather ineffective, rather inefficient, not to say rather inexistent. So what we can see is a very strong scarcity of effective dispute settlement means or mechanisms in the constellation of African water agreements. And sometimes this scarcity leads even to some very strange, some very weird situations, because we have some agreements in Africa that are, for instance, saying that water disputes should be solved by the Conciliation Commission of the African Union, which is a commission that does not exist. And you have very recent water agreements that are referring disputes to a Conciliation Commission that does not exist. So it shows what I would call the scarcity in terms of dispute settlement mechanisms. The main reason why African countries have been reluctant to incorporate effective dispute settlement mechanisms in water agreements is because they believe very much in water diplomacy. They have this very strong faith that diplomacy can solve water tensions, water conflicts, etc. But I think that today, when we look at the practice, when we look at the reality on the African continent, we need to acknowledge that efficient water diplomacy needs effective dispute resolution mechanism. And the very recent example of the Nile negotiations that you were referring to, Attila, is revealing at that level. We know that one of the reasons, of course there are many reasons, but one of the reasons why Egypt, Ethiopia, and Sudan were not able to conclude an agreement on the Grand Ethiopian Renaissance Dam, it's because they did not agree on what would be the nature of the dispute resolution system under such an agreement. Egypt and Sudan are pushing for something that would be more of a binding dispute resolution system, while Ethiopia is more in favor of something that is political. And this agreement that is one of the causes of the failure in concluding an agreement. So all that to say that the model of the implementation committee can really shape future dispute settlement mechanisms in Africa, because as many of the colleagues have said here, it presents features that can actually reconcile, that can be the third way between something very binding and something that is of a more facilitative, more flexible nature. But I don't think that the implementation committee can only shape future dispute settlement mechanisms in Africa in the context of water agreements. I think also that recourse as such to the implementation committee can be something very useful, and that the implementation committee of the 1992 Water Convention can play the role of a gap filler in the context of African river basin organizations. Let's not forget that some African countries are parties to the Water Convention. Now we have Chad, we have Ghana, we have Senegal. So what does it mean? It means that in particular this advisory procedure, which is, I agree with Malgosia, fascinating, the advisory procedure that allows actually to request an advisory opinion in relation to non-parties. So these countries, Senegal, when you talk about Senegal, you talk about the Senegal River Basin. When you talk about Chad, you talk about the Lake Chad Basin. Ghana, many other river basin in Africa. So only these 3 countries, they represent a geographical context of almost 20 countries, 20 riparian countries. So imagine the potential that the advisory procedure is offering for these parties to actually request advisory opinions when they have difficulties, differences, disputes with these other riparian countries that are with whom they are sharing river basin. So there is really a huge potential there to be used. And you know what I think is very powerful also with the model of the implementation committee under the Water Convention is that there is also the shift from technical assistance to legal assistance. The fact that under the advisory procedure, the committee can recommend or suggest domestic regulatory regimes to be set up. The fact that the committee can recommend or assist in the establishment of transboundary water agreements. This is what we need. This is what we need in many contexts in Africa to actually prevent transboundary water crisis. So if you allow me just, Attila, as a conclusion,
please.
As a conclusion, I have 3 elements. I have 3 prospective elements, 3 prospective proposals to ensure a better relationship between Africa and the implementation committee. My first proposal is that I think we should one day contemplate allowing non-parties to self-trigger, non-parties that are parties to agreements that make a renvoi to the 1992 convention to self-trigger the advisory procedure. You know, in Africa, we have some water agreements. If you take the Niger Water Charter of 2007, if you take the Lake Chad Basin Water Charter of 2011, if you take the 2017 Convention on the Prevention of conflicts related to the management of shared water resources in Central Africa, each of those instruments make a renvoi to the Water Convention. So we should be able to allow non-parties, but who are parties to those conventions, to self-trigger the implementation committee, the advisory procedure. Second proposal, I think it would be good to think in the future of giving the possibility to countries, not only in Africa, but also elsewhere, why not in Latin America or in Asia, giving to countries that are concluding water agreements to insert a provision in which they would accept that in case of dispute, they can submit the dispute for an advisory opinion of the implementation committee under the Water Convention. This would be a model that is similar to what we have under Article 138 of the rules of the International Tribunal of the Law of the Sea. If you check Article 138 of the rules of ITLOS, there is a provision that is saying that countries can conclude agreements that are, pursuing the same objective than the United Nations Convention on the Law of the Sea, and those agreements can actually, give competence, give jurisdiction to the International Tribunal for the Law of the Sea to render advisory opinion. So I think we can think about a similar model that could help once again filling the gap. And then last but not least, a third prospective element. I like very much, of course, the part of the rules of the implementation committee regarding to the enhancement of synergies. I think it's great, the enhancement of synergies. It was something that was also in the compliance mechanism and the protocol on health and water. It's something also similar to the compliance mechanism of ARIS. But I think it's great that your implementation committee is also strengthening this idea of enhancement of synergies. But something I would suggest is that the synergies in paragraph 2 of that part shouldn't just be limited to secretariats of environmental agreements. We need also to think about river basin organizations. It would be very good for the implementation committee, whenever appropriate, to share information, to communicate information on its practice to river basin organizations. And I believe that this might be also a tool that would allow better knowledge, broader knowledge of this great mechanism, and maybe push many countries to join what I believe is a futuristic and unprecedented mechanism in the constellation of compliance today. So thank you very much. This is what I wanted to share. Thank you.
Well, thank you very much. You shared a lot that has been very generous and very interesting and useful, particularly with regard to the propositive side, of which I'm sure much has been, if not everything, has been taken note of by the Secretariat, and the Bureau of the Convention will be made aware of this very, very soon, because it's very, very appropriate. We already have within the existing framework reference to the possibility of non-parties to the convention accepting to take part to some extent in the process based on their will. I would have a provocative question that you don't need to answer to now, but then fine giving non-parties the possibility to resort to the implementation committee. But if they were to be so willing, why not joining the convention altogether? But we'll discuss it with a glass of wine in Geneva one day. You have already projected us into the second rubrics of our discussion, together with Jimena, who has also entered into the domain of the relationship between the implementation committee and adjudication. But before we get there, of course, today we heard twice referring to what is called a new area. Whether it is a new or an old area, I don't know, but the area of Transboundary water cooperation being funded internationally. We know that we have had for many years international funding for transboundary water projects. And we know that no such funding would be made available unless the interested parties, when there was a transboundary investment of the kind, were not in harmony. And the World Bank has played a major role, tremendous role in the past. But Christina, you may tell us about developments and in that area, and how the implementation committee could play a role in facilitating international financial agencies in providing aid to that end, as we were supposed to be discussing in Geneva and we couldn't. Please.
Yeah, thank you, Attila, and thank you, Martins, also for the invitation. It's a true pleasure, like listening to Makan. I want to go back to Geneva and have heated debates about the various theoretical aspects of law and implementation and compliance of law. Alas, I'm stuck in the practical aspects. So I would like to make 2 points, and one relates also to that multi-layered system of implementation and compliance support that Catherine was already talking about, and you referred to Attila. And the second one on sort of this, the potential role of the implementation committee. And one of the key aspects which I wanted to highlight on implementation committees is also sort of, in addition to the advisory role, the role of feeding into the evolution of the roles against which compliance is assessed. And it goes back a little bit also to the experience we have with our own accountability and compliance mechanism. So to the role, and also to the role of the World Bank in this sort of this multi-layered, not directly treaty-related global system of compliance and implementation support. That's where sort of the World Bank, other multilateral development banks, and also bilateral development partners are very important. As Sonia mentioned earlier this morning, the financing and also the technical assistance, but bringing sort of global experience is key for countries to meet compliance. And maybe if I can make a little bit of a reference to sort of the role that I have, I sit in a very cushy niche department in the World Bank, where we are a small group of international environmental lawyers, making sure that our own policies that ultimately govern our investment projects do comply and promote the principles of international law. And so we, for instance, make sure that our new environmental and social framework includes a provision that mandates us to support compliance of international obligations from client countries. And that is, of course, very important because the financial institutions have such an important role in helping countries to comply with the international obligations, to implement them. And how do we do that? I mean, the World Bank being sort of one of these first international development banks has a big role in the finance as we are trustee to most of the financial mechanisms that are financial mechanisms for the compliance with environmental obligations, such as the Global Environmental Facility. We have multiple trust funds that support implementation and compliance with the UNFCCC. So that's sort of where the World Bank comes in as a funder. And in that role, sort of in my role on the water side, we really appreciate the close collaboration with the UNECE Secretariat, because it provides this platform for client countries and not only parties to the convention, but also, as Makan referred to, this importance of providing the platform also to non-parties of the convention to have information exchange and knowledge exchange of how do we implement the principles of international water law. And that's also where the expertise and advice from the implementation committee from the UNECE convention comes in. And these knowledge exchange platforms are very relevant for client countries because they do allow setting up connections between countries where they can exchange experience on how best to comply with their international environmental obligations. One role I wanted to get back to, which I find very important, of compliance and implementation committees more generally, but it's not always included explicitly in their mandates, is this role of feeding into processes of the evolution of norms. There is a lot of knowledge that comes out when assessing compliance in the sense of sort of assessing an act against the threshold of the legal norm. And we know from our inspection panel that we might be found in compliance with our own policies with respect to environmental and social safeguards, but that these norms might not be perfect because they're not actually addressing the grievances of the project affected people that have brought the case for the inspection panel. So in that sense, the compliance mechanism, and we have sort of a feedback mechanism of the lessons learned from our own inspection panel, can help in informing the evolution of norms, in making the norms better against which compliance will be assessed in the future. It's of course much easier in international organizations where we make our own policies within the framework of our constituent agreements, and those are not international treaties that need to be negotiated between countries. But we should nevertheless underestimate this important role that also feeds into the overall evolution of the international legal system, which we have seen sort of over the past hundreds of years has really evolved into a beautiful system of getting us more and more on track to really focusing on sustainable development in terms of environmental protection, protection of our natural resources, so that we can also benefit future generations. And maybe I end here and we can pick it up again if we get to it, the third round on the role of the implementation committee in the teachings of international law. Thank you.
Thank you very much. I suspect we covered quite some ground, but I suspect we are running out of time. And that is why I would quickly turn to our second rubric, which has already been addressed by Ambassador Jimena Fuentes and largely by Professor Benge. I would then elicit quick, very short remarks of about 2 minutes to those who haven't already addressed the issue, and perhaps I could give the floor again to Malgosia for a quick remark on the relationship between compliance, implementation review committees and international adjudication, if you so wish, Malgosia, of course.
Thank you so much. So again, I will give a short overview, general, of the settlement of disputes procedure and implementation compliance procedure. So basically, all the multilateral environmental agreements have traditionally, as all the treaties in international law, article on settlement of dispute procedure. And this relates to 1997 UN Watercourses Convention. It relates to Vienna Convention on Protection of Ozone Layer, and it relates to the Water Convention, Article 22. So obviously this article, all these systems are a bit different. The only unifying feature is that they need a special declaration to submit the dispute to legal means, so arbitration and International Court of Justice. Otherwise, they rely on a whole variety of diplomatic means, and I think the most flexible formulation is in Article 22 of the Water Convention, which just means, says that if a dispute arises, two or more parts shall seek a solution by negotiation or by any other means of dispute settlement. It's acceptable to them. Whereas other Montreal Protocol and the Water Convention, they are a little bit more, I would say, ornate. So if the states didn't achieve any agreement, they either have to rely on conciliation commission or to go to a fact-finding commission, for instance, in relation to the 1997 convention. So I would like generally to say that already in a very insightful article in 1992, Martti Koskaniemi actually commented on the relationship between non-compliance procedures or implementation procedures and settlement of disputes. And he said that obviously, although it says that both procedures are not prejudicial to each other, he looked at it from the practical point of view, i.e. what happens to a state which is sub judice in legal proceedings and at the same time is threatened with suspension of rights, in particular under the procedure of compliance body. He said, in his view, the procedure in the implementation body should be immediately suspended as not to encroach on rights of a state under both proceedings. On the other hand, he was of the view that the diplomatic means which would run parallel would be beneficial to state in a dispute as maybe to facilitate some kind of agreement. The same obviously related to facilitative means applied by the implementation body. So he in particular took an exception to parallel proceedings between legal means in the court and possibility of suspension and rights. However, I have a good example from practice where even diplomatic means of diplomatic means of settlement and disputes and the parallel non-compliance procedures were somewhat in conflict. And this relates to the case between Romania and Ukraine, which had both used first the inquiry procedure under the ESPO Convention on transboundary impact assessment, and also used Aarhus Convention Implementation Committee because it was on lack of information on transboundary impact and also lack of public participation. And very interestingly, the inquiry article 3 of the ESPO Convention and Appendix 2 on this inquiry commission to the convention rules that when inquiry commission is activated, then all other proceedings should stop. So then the Aarhus Convention Committee agreed with this and waited for the inquiry commission result. However, the question remained unresolved because they were legal issues connected with what is the legal effect of the inquiry commission. So it wasn't fully resolved. So I would say that indeed, I go back to Marty's article, and I am of the view also that the harsher means in applied by implementation committees should maybe be in conflict with settlement of disputes procedure. However, in light of new developments which are embodied by the implementation committee of the Water Your Convention, Attila, I think that maybe this question is a little bit now old-fashioned, because when we look at the new direction, like POP's Convention, for instance, and the Paris Agreement, we see that it's softer approach, that it's facilitative approach, which is an approach which should help state to get into the into implementation of the agreement. And again, in particular, I single out the advisory proceedings, which actually would not in any way, in my view, be in conflict with settlement of dispute procedure. Thank you.
Well, thank you very much, Malgosia. Obviously, that was, again, very comprehensive, including reference to the Bistro Canal case. And you were so comprehensive that at this point, I wouldn't dare to ask anyone else to take the floor, not because he or she may not have to add their comments on the issue, but we have Philippe Sands in the virtual room, and I have to acknowledge my inability to keep the time to let everyone make more than one comment, including addressing questions coming from the audience. I take responsibility for that, but I wouldn't want to add to that also responsibility vis-a-vis Philippe. So on a balance, I'm very pleased to give you, with all the responsibilities involved, Philippe, the floor. And thank you very much for coming. I know that you've been jumping from one courtroom and you're going to another meeting. Thank you very much for being with us, Philippe. You have the floor.
Thank you, Attila. But honestly, if you want to have another 10 minutes to conclude your conversation, I'm completely comfortable with that. I just, I don't want to, I mean, I think a couple of people perhaps wanted still to speak. So if you want to do that, that's fine. But
you speak, Philippe, and you wind up whenever you feel like it. And if you end up before time and there is someone else who wants to make a statement or put a question, I am available. You have been kindly made yourself, you have made it yourself available. You have the floor.
Thank you so much, Attila, and it's so lovely to see some familiar faces and friends. And I'm so sorry that I haven't been with you today. I've been sitting in my room in London, but actually in The Hague, being clobbered by other friends, by the representatives of Uganda against the Congo, which I happen to be acting for. Curiously, of course, as some of you will know, that is a case which many of us appeared in about 15 years ago, and then it disappeared, and now has come back when the court is charged with dealing with matters of proof. And the only case that has been on the docket longer than Democratic Republic of Congo versus Uganda is, of course, Hungary versus Slovakia, which remains amazingly still on the docket of the International Court of Justice. It's a case that I have a particular fondness for because it was the first contentious case that I was involved in. I've been involved in an advisory opinion, but that was the first contentious case. So it was a really very interesting for me, and I know there are others here. I see Malgosha here who knows that case really well, will understand why I make reference to it in the context of your conversation today. And to jump straight into the issues, I have to say that one of my big takeaways from the Gabčíkovo-Nážmaros case was a very big question about whether courts had the capacity to deal with these kinds of situations. Did they have the requisite scientific, technical, and it has to be said, legal expertise to be able to meld all the different aspects? I mean, when you're involved in a case, you tend to have a certain pride of association with the judgment, but when you look back to that judgment, it becomes pretty clear that what the court actually did was it sidestepped all the difficult issues. It took refuge in what judges in those days at the International Court of Justice knew about, which was the law. But in 96, 97, the environment and the protection of water quality and the idea of sustainable development and pollution by different means and the word biodiversity was, shall we say, a challenge for the court. I remember one of the anecdotes that emerged was there was a site visit, which had been the first by the court in a case such as that ever. There have been other site visits subsequently. But in that site visit, in the course of that site visit, one of the judges was overheard to say to the other judge, to another judge, look, they can't even decide what to call this dispute. One calls it the Gabčíkovo dispute, the other one calls it the Nážmaros dispute. So even after the case had been fully pleaded, some of the judges at least were in a state of confusion about the relationship between one river and two barrages. Now, I've got to say, things have improved a lot at the International Court of Justice since the late 1990s. And particularly if you want to address the question of an international court's ability to deal with matters of science. I'm thinking of the whaling case, Australia and Japan, not of course involving a river, but there you had judges who really rolled up their sleeves and got their hands dirty in the muck of scientific evidence. And I think did a very serious job in trying to grapple with the complexities of the relationship between technical matters and legal matters. And of course, in between, we had the pulp mills case, in which, again, in essence, the court sort of sidestepped some of the more difficult scientific issues. And this has been a particular theme that I've become increasingly interested in. I have to say, not just in the field of environment and sustainable development and natural resources, but the capacity of international courts to deal with matters that are politically sensitive, ecologically sensitive, and the need to think through alternative mechanisms. I mean, in the field of human rights and criminal justice, that of course has happened as bodies have been created in relation to truth and reconciliation, where it's recognized that a court has a function, but its function can never be complete. And I think that's the context in which I situate the conversation that you've been having today about the implementation committee. I remember when the 91 convention was adopted, it was really exciting. It was, I can see Malgosha smiling. We remember those glory days of the early 1990s when the environment was really growing big time. We were in the run-up to the UN meeting in Rio, biodiversity convention, climate change convention, Watercourses convention, ESPU on environmental, etc. I mean, it was a really exciting time, actually, and it was a real privilege to be part of it. And those set norms. I listened to Christina Leb's comment on what we do with these norms. The norms are there. The question is, what do we do with them? And I have to say, pretty skeptical about the role of courts as being ultimately the place that can sort out these kinds of issues. And so the creation of the implementation committee was, for me, an exciting idea. And of course, it's been mirrored now in many other domains. It's the sort of environmental equivalent to truth and reconciliation. So my predisposition is that over the long run, this is the way forward. It's something of a surprise to me that greater use has not been made of these non-judicial or arbitral means. And I've wondered why that is. Quite wrongly, it seems that in the world of classical international law, they're not seen as very sexy. People don't teach about them in courses about international law. For the most part, there are honorable exceptions. And yet when you begin to dig away at what they actually do, they're completely fascinating. So I did look at the reports, actually, in relation to the Albania-Montenegro matter. Attila, you with your colleagues have spent time on this. Martins obviously has been very involved also. And I was fascinated by it. It just seemed to me that in the sense of using the law with input from folk who are not lawyers, but who are scientists or specialists in areas with technical expertise that are inevitably going to become significant when you're dealing with watercourses, it's absolutely sensible to have those kinds of people on board. I mean, the International Court of Justice, I think, is beginning to recognize that. I've literally come from a hearing today, which is a preparation for tomorrow's examination of 4 experts appointed by the court on the matter of reparation. And I find it very interesting that the court now has grasped, finally, this need to reach out beyond its own expertise, not rely only on the expertise of parties in a contentious, confrontational, judicial or arbitral type of process, but appoint its own experts. And that, in a sense, mirrors the development of the implementation committee. So Albania-Montenegro strikes me as an extraordinarily successful outcome. You read a report in which both sides appear to commend, to reach a degree of agreement, to engage cooperatively in matters of assessment and monitoring. And you compare that with the experience, going back to where I started with, on Gabčíkovo and Nažimaroš, and you ask yourself, what is the more socially useful way to go? It just seems to me that that is a no-brainer. If you can preempt conflict, if you can nip in the bud a long-standing contentious dispute. I mean, it has been 24 years since the Gabčíkovo-Nažimaroš judgment, and the two sides have still not been able to agree to remove it from the docket. That tells you a lot. There must be better ways. There must be more efficient ways. And I think the implementation committee type of approach is, I think, one of those ways. Let me just conclude with the point that I think I have in part already made, and that is the need for lawyers to reach beyond their own communities. I mean, from the very first Watercourses case that I was involved in, it was an incredible joy to work with the scientists on both sides. You know, it's a confrontational type of process, but you have the experience, and I know others here have had the similar experience. You sit in court and you listen to the other side's scientific experts and you think, wow, that seemed pretty persuasive to me. And then you listen to your own experts and then you hear the rebuttals and you think, yeah, well, maybe there's something there. But the joy of being able to work with, as part of the team, experts in other fields seems to me what is special about your implementation committee. And I would really encourage you, Attila and Martins and others, to write up about that experience. What are the best practices for lawyers working with experts, whether in relation to watercourses or ecological matters. I mean, I'm working with Christina Voigt right now on a really intellectually, I'm finding it very intellectually challenging effort to see whether we can come up with a definition of ecocide. And this isn't something that can just be left to the lawyers. Obviously, you have to involve those people who really know about ecosystems and biodiversity and plants and animals and trees and other things which we don't know about. And so for me, one of the big takeaways and one of the questions that I've got in relation to the implementation committee is whether you could draw on best practices on how it is to sit with equal colleagues who are not lawyers in trying to assist countries or other stakeholders to reach a consensual type of approach. And in a sense, what you have done is contributed to taking lawyers out of their little ghettos. We are all of us in our little ghettos, in our law faculties or law firms or wherever we are. And I suspect for a lot of us, the moment you get outside there and find yourself connecting, as probably everyone on this call has, with people who bring different expertise, different substantive knowledge from whom you can learn so much, it's a great experience. But I think law students need to know about that, because I think the law students don't know about things like the implementation committee. They don't know how a lawyer interacts with a scientist, interacts with an economist, how those different approaches intellectually to dealing with the same or related issues actually meld in practice. I've begun to see that in some instances where I sit as an arbitrator and we bring in an expert to assist us, and it can be an absolute game changer in terms of how you think about the problem, how you think about the issue that you have to address. So it seems to me that's where the rubber hits the road. That's where the implementation committee has made a huge difference. And I think if I can encourage you to share your expertise from within the limits of what is possible in terms of confidentiality and so on and so forth, I think that would be enormously helpful. I think that's where the future is. It's not lawyers sitting as adjudicators, solomonically giving judgments. It's lawyers working cooperatively with folk with other areas of expertise, dealing with issues often even before they arise or as they arise, to find sustainable solutions for dealing with them as you go forward. That's not what the law books teach about in international law, I'm sorry to say. I wish they would. This is a way of sort of expressing real admiration for what the implementation committee is doing discreetly in a corner. And I think, judging by your latest report, rather effectively. Thank you so much for inviting me to say a few words.
Thank you very much, Philip, for your words of encouragement to us. And I hope that could be encouragement also to state representatives somewhere in the spilling over of our debate, because as you know, and this is germane to our topic, you can take the horse to the waters, but you can't make it drink. The successful outcome of our activity very much depends on the confidence that we can attain from states, and the confidence that states may put on the legal process and on their neighbors and co-riparians. But if there is a need for us, a willingness to come to bodies which adopt an integrated approach between science, policy, and law, I think bodies of this kind are increasingly put on the market, and very willingly and happily so. I would pass the floor on to Martins for a closing remark and keeping the reins of the ending of our event. Again, many thanks to everyone, to my panelists, the audience, and Philippe and Martins, yourself.
Well, many thanks, Attila. Many thanks, Philippe. Many thanks to the absolutely fantastic panel. I think I probably was not the only one of feeling that we could just go on for hours and hours and really untangling each intervention for long conferences. It was great having you, and as I said in my opening remarks, we hope that this event will be a useful resource for those reflecting on these extremely important topics of law, science, politics, institution building. The video will be embedded on the page, the PowerPoint presentations will be provided on page, and you also have the bibliography provided there. With that, it is my pleasure to close this fantastic conference. Thank you very much.